maybe you tell it always open and then go reboot it and see what happens. Okay, so then. Still not really.
The meeting has started.
Oh yeah, there. And okay, so that's what you have to do. Okay,
Yeah,
so then
we have to go.
you have to go to the machines and tell it.
So you do see the stream?
So you just got to check this checkbox. Okay, so let's try it on this. So then go.
No,
so where
you
it's-
should be getting.
Once it's downloaded, you can do it with any attachment.
Okay.
Oh, yours is already doing that.
Yes. Can you give me sound check? Sound check. Sound check. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay. Okay, I'm pausing it.
So
They're at lunch,
Joe,
so
he just needs to go to
that's
each
good.
machine and download any.
Okay, thank you.
Sure. You're welcome. How are you doing?
No.
That's it now. That's like most of it.
Oh, you talking about her?
Christian cultural. Unless the young, American born. Something that sure not with it. It's something that if you don't have
Are you in extended? It doesn't matter whether it's open or closed.
Good afternoon, everyone. This is the open session on Ed Standards. My name is Alex Lawrence. I'm the chair of Ed Standards. And before we get started, I wanted to first have Ms. Kim Wong do roll call.
Paul Kramer,
Here.
Anjali Agate, here. Alex Chen, Karim Gongora,
Present.
Karen Goodman,
Here.
Bethany Pick, here, and David Torres.
Here.
Great. And again, just for visibility, if you're not on the committee, if you can kind of move to the back, that would be very helpful. Fantastic. Again, I want to welcome all of you to today's session. We have a full agenda items to discuss. As mentioned earlier, please, if you have a question or comment, especially during the public comment session or period, please use the microphone and the seat there noted in the back. Please announce who you are, speak clearly into the microphone and slowly so that our guests that are not with us and online can understand who you are. So at this time, we're going to welcome comments from the public. They can sit there, as I mentioned before, in the back on any of the items. So again, this is the public comments opportunity. I don't see any, so we're going to go right into the first item on our open agenda, and that is item 0400, Macmillan Academy of Law, the inspection report. So Macmillan was first registered as an unaccredited law school in 2007. It received its first notice of noncompliance in 2008. The school's 5-year periodic inspection in 2012 A number of mandatory recommendations were identified by the inspector. Committee ordered a follow-up inspection to make sure those recommendations were addressed. After that inspection in 2013, the school's registration was extended through 2017. Between the period of 2013 and 2017, McMillan didn't enroll any students, maintain its library, or update any information. The school's second and most recent 5-year periodic inspection took place in May 2017. The inspector found 5 material areas of non-compliance. Many areas of compliance were difficult to assess due to the lack of students, faculty, and classes. Based on the findings summarized in the inspection report, the committee issued a notice of non-compliance to McMillan in December 2007. The school did respond to the notice, and the committee directed a further inspection of McMillan. That inspection was conducted on May 9th, 2018. During the inspection, there were students present and a faculty member had been retained, allowing for review of student files, classes, and examinations. Some progress had been made, but new instances of non-compliance were found during the recent inspection. At this time, I'd like to ask staff to add any additional input. Natalie?
I think that's a sufficient introduction to begin the discussion.
So I'd like to open up to committee members. Questions or comments?
I have a question. Just not having participated in either one of the inspections, for the people that have participated, can you explain the progress that appeared to have been made?
Sure, I'd be happy to do that. So because it is a registered and accredited school, we had one inspector with a consultant, Sally Aaron, and the process is very similar to what you might have experienced being part of an inspection team. The school had a self-study. They had ample time to prepare for the self-study. It was provided in advance, some guidance was given in advance, et cetera, and then it was conducted. In terms of the progress that they made, the progress was primarily in the area of the library. The library had not been updated in any fashion since 2013. Now they received the correct amount of books, but many of them have not been shelved or opened. They also retained a faculty member that began to teach a class with certain students. So those were the improvements that we're seeing.
Thank you.
There aren't that many students that, there weren't that many students that are going to be affected by this.
That's correct. So 3 students were observed at the inspection. None of them are being charged tuition or fees at this time, so they may bring that to your attention. One was actually deemed ineligible and will need to be disenrolled from the school. The other had enrolled just that day on May 9th, so they've expended very little time at the school.
Is there a possibility that the school did not itself because of this, because of the lack of students may just cease to continue to exist?
On its own, we don't believe so. The consultant did informally discuss the findings and the additional areas of non-compliance and the additional areas that still could not be assessed. And the owner, Dean, indicated that he wanted to continue to work toward compliance.
So is it true, can I ask another question? Oh, sorry about that.
I just wanted to mention, there is also no requirement for a minimum number of students at a school and stuff.
So ready on it, Alex? In the report, staff writes, says each time the school has been inspected, the state bar has found the school to be clearly out of compliance with multiple guidelines. So it would be fair to say that we've had a history of McMillan disregarding the guidelines. Is that true?
I would say that that's correct, and they will respond, and they have made some response here, but you also see repeated issues. Sorry, they will respond, but you do see repeated issues. So they gain the knowledge that they're not complying with the guideline, they respond to a notice, and then they fall out of compliance again in that same area.
Mr.
Chair, quick comment. So my understanding is the school opened in 2007, but has been non-compliant since 2008.
There have been issues of
Non-compliance throughout.
So the issues identified in 2008 related to the disclosure, they were cured at that time. The issues in 2012 were numerous, 14 in fact, and required an additional inspection. They were cured. These newest issues have not yet been cured, and many of them are the issues that had happened previously and were allowed to reemerge.
Okay. All right, thank you, I appreciate that.
Are there any other questions or comments?
Yeah, in total, how many infractions does the school have, and of those infractions, how many is it cured?
Here, there are actually 5 families and guidelines, and of those 5 families, one was fully addressed, and another was partially addressed. And there are still other guidelines relating to, for example, clinical requirements, where there is simply no evidence that the school has those plans in place for students beyond 1 year.
And all of these infractions have been, or they have been notified about these infractions for a number of years. Is that correct?
Well, they've been notified as of the time of the inspection. They were inspected in May. They received verbal notice in May. They received written notice in December. They received another inspection. This one took place in May. And so anything that remains uncured now will be at least through that time period since May of 2017.
So we have definitely given them that opportunity to cure, but they decided not to cure those things.
To the extent that that number of months would be, yes, they would receive about 14 months to comply.
Thank you.
Question. Is anyone from Macmillan here? Okay. I'm ready to make a motion if there's no discussion.
So if there are no other questions or comments, okay, yes, Paul?
Okay, so Natalie wrote out a motion in the staff report, and it's basically to, in effect, I'm making that motion, which is to receive and file the report, send a copy of it, the supplemental inspection report to Macmillan, and inform Macmillan that the committee, Natalie used the phrase intends to recommend withdrawal of this registration effective January 1 of 2019, but are we actually withdrawing it by this action? Is that what you intend?
That's the first step in the process. So the guidelines require this notice of intent step. The notice would be provided immediately after this meeting.
Okay, and then would it come back to us at some point then for further action, or is it self-executing?
It will come back to the committee most likely in August, either with a request from Macmillan for a hearing or to confirm this action.
Okay, so then that's my motion that, among other things, we inform them that we intend to recommend withdrawal of the registration and all the other things I mentioned.
I'll second that, Mr. Chair.
All those in favor say aye.
Aye.
Those that oppose, any abstention? That carries. Item 0401, Lady Justice Law School, major change request to relocate the school. So the Lady Justice Law School is a fixed facility, part-time law school located in Bakersfield. Its lease is up on June 30th, 2018, and school wishes to move to a new site, primarily for 3 reasons, not in this order. The move will offer a lower cost that can be passed on to the students. It's in a central location, and now is a convenient time to move now that the students will be on break, and move can be completed before the start of the fall trimester, beginning in August 2018. So, Natalie, any additional input?
Simply that in terms of timing, at the next meeting, you'll be receiving a periodic inspection of Lady Justice Law School, so it typically wouldn't be inspected again for 5 years. So that's the reason that the staff proposal has a recommendation, just to check in on the status of the facility once the move is complete at the end of the summer. And we may have some guidance on that meeting regarding space and water. Yeah, I went by the space, just drove by, I didn't go inside the building, but I do agree with their assertion that it's a better location for a law school. It's closer to the two main courthouses in Bakersfield, the civil court and the criminal court. They mentioned that they're closer to the library that's inside the court, which is true. It's just, it's also closer to the bar office where we have a lot of our bar-related events, so if they want to be more active in the legal community, I think it's better in that regard also.
Any questions or comments from committee members? Is there a question?
No, just let me-
No.
Yeah, it's not apparent to me based on the letter if they have secured a lease for this new space. If so, how many years is the lease?
They do have a pending lease. I actually am not certain of the term of the lease. I'd be happy to confirm that for the community.
So if the lease is pending, does that mean it's not confirmed?
I know that they are able to sign, or they ask for a clause in the lease, for the conveying people because they do need that to
Okay.
So in a way, that's kind of prudent that they're waiting to see if we'll approve it. A lot of people don't do that.
Yeah, that's a whole nother issue.
I had one question. I didn't see a law library in their drawing of the space, so what's up with that?
No, and that's something that we've already asked them about to discuss at length in the periodic inspection report, which is still open back on my desk. They have a library right now, and it is a compliant library. This new space is larger, but I know that they intend to lean more heavily on the library, which is at a distance from the school. So we intend to get more detail regarding the location of the library volumes and the availability and accessibility of the library, the county law library. So right now they're about 10 minutes drive from that. Now they'll be like approximately 8 blocks.
So would it be acceptable for them to rely on the county law library and not have books in their own facility?
It may be so in conjunction with the LexisNexis that they also offer, and so that'll be something that I think will be ministerially confirmed through the periodic inspection.
Do we know how many students will be affected by this move?
I believe that it's approximately 8 students.
5 students.
It's about a 10 long.
Mr. Chair. So in regards to the periodic inspection, that will take place in September, or does that take place in August?
It actually already took place on May 30th.
Oh, okay.
And so I'm working with draft report now, and quite often, as the report is created, there are additional questions. At the time of the inspection, that was the time that they also realized they could receive this lease, which they felt to be more advantageous, and so those discussions happened at the
And
same
the
time.
progress report would take place once they fill the facility, right? Is that what
Yes.
that's what I'm trying to get towards, when we'll hear back about how they're doing?
One of two things will happen. If the move is quite quick and complete at the beginning of July, it can be wrapped into the periodic inspection that you'll receive in August. If for some reason it takes time, such as time for the setup of the library, then the thought would be that it would be conducted in September, when we will already be visiting Bakersfield to inspect another school.
Oh, okay. I think it'd be more appropriate for students to be there, just to see if there's any, I don't know, any questions. Do you typically ask students questions during the periodic inspection?
We do, and we did meet through the consultant with students in the May inspection, and could do so through a visit in September. Yes.
Thank you so much.
So I'll make the motion to agree with the recommendation, move that the request submitted pursuant to 4.245 to seek approval of a major change that would allow the Lady Justice Law School to relocate.
To which I'll second, Mr. Chair.
Thank you. All those in favor say aye.
Hmm.
Those who oppose? Any abstentions?
One question though, where did that fit as far as the informal reinspection of the new site? Just to see how it works after the move. The motion leaves that open to us requesting it, but is it clear that the motion is requesting that they revisit the site once they move?
That was the part of staff's recommendation, I believe.
Yes.
Okay.
Did you want clarity on timing?
Oh, no, I think that it might be better for them to just see how it goes, visit the website.
Great. Open item 402, California Desert Trail Academy College of Law, their progress report on its hybrid JD program. The school is a registered, unaccredited law school located in the Coachella Valley. It was registered, the law school was registered in 2012. The current enrollment is about 25 students. If you read the information, the report that they provided was a little bit light, but I'm going to ask Natalie, who has a little bit more experience with this program, to add some input.
Sure. So they would say that they had a very successful year with this program. Their intention, and so far the way they've been carrying out this program, is that they have classes 4 times per week. So they use an online participation for those in the online program during the 3 weekday classes, and then the students attend live on Saturdays. Everyone drives in on Saturday. So the school hopes that this will allow them to drive the students within about a 100-mile radius from the school. It wouldn't be possible to do that drive during the week, but it would be on a Saturday. During the first pilot year, they included 1L students who were interested and 1 pilot 2L. Also, we tried an experiment in which professors taught 2 classes remotely. So people attended live, but watched the professor from a remote location. They found the platform to be very stable. They had very few technical issues, and the students were very happy with it. This is a particularly flexible hybrid program. A student could decide on a given day whether to attend live or to attend online, and that's their intention going forward. They thought that they would roll out the program 1 grade at a time, but they felt they had so much success in the first year that in the second year it would be open to all 4 years at California Desert. What we don't know yet is how those students will perform on the first-year law students exam. So the first class of students who participated in the online hybrid will be taking the exam just this upcoming week, and more data will come as time passes.
Discussion?
Move to receive and file the report.
Can you get a second?
Second.
All those in favor? Those opposed? Any abstentions? No. Okay. Open item 403. Notice of changes in law school administrators. There are 2 California accredited law schools that notified the committee of the following changes. The Empire College School of Law, the Dean of the Empire College School of Law, Dean Michael Mullins, will be resigning his position effective June 29th, and they haven't identified a successor yet, but they will do so as soon as possible. And then the San Francisco Law School, effective May 20th, 2018, Timothy Weimer is the registrar for both the San Francisco Law School and the San Diego Law School branch. He is replacing Paul Welch, who was the registrar of Alliant International University and had been serving as the interim registrar since the retirement of Ms. Pat Alley back in December 2017. You have anything to add, Natalie?
You may be interested to know that regarding Empire College of Law, Dean Mullins is going into partial retirement. He will also be a volunteer supervisor at Sonoma County Legal Aid going forward, so he continues a career in service.
And then there is one more school, an unaccredited law school, has notified the committee as well. California Southern University School of Law. Dr. Glenn Feinstein has been appointed the president of California Southern University School of Law, and that letter was dated May 11, 2018. Dr. Feinstein will be replacing Dr. Hecht, who had been serving as the interim president since May 12, 2017. Any additional information on that? No action required on that. Open item 404, Lincoln Law Law School of San Jose, a major change request, acquiescence to MLS joint, MLS JD, and LLM degrees. I'm actually going to ask Natalie to provide some background information on this.
Sure. So Lincoln Law School San Jose is of course located in San Jose. Lincoln Law School San Jose is of course located in San Jose, California. It is a longtime California accredited law school. They are seeking to add 3 master's programs. The committee acquiesces to these programs, so it doesn't approve the content specifically or regulate the content, but it acquiesces to ensure that this program will not have a negative impact on the JD program. Many other CALs already have master's type programs similar to this. It may lead, for example, to WASC accreditation, but would also allow the school to access student loans. I'm not aware as to whether that is part of Lincoln Law School San Jose's plan. That was not mentioned in the application. It's something that you may want to know. The details of those programs are here. Generally, these programs are, and these particular programs will be overlays on the JD program, sharing the space, sharing the faculty, and sharing the coursework to create compliant programs. And we do have a Dean Calzone here in residence today.
Dean Calzo, would you like to make any comment or offer any additional information at this time?
I think that the
It's not on.
It's red, it's on.
Yeah, got it. I think that the application and Ms. Leonard's comments are sufficient, but I am here to answer questions if there are any.
So now I'd like to open up to the committee for any questions or comments. Doesn't appear that there are any questions, so at this time, is there a motion?
I'll move to accept staff recommendations.
All those in favor, say aye.
Aye.
Any opposed? Any abstentions? No. Thank you. Item 0405, 2017-18 Subcommittee on Ed Standards or Goals for the year. I'm not going to read each goal line item by line item, but are there any modifications or as any committee member wants to make? Any questions or comments? No? Okay.
Alex?
Yes, go ahead, Alex.
I do. Yes. Mr. Chair, I just wanted to raise an issue that is, I guess, constitutes the heart and soul of this subcommittee. I was actually looking at the recent statistics of the February 2018 California bar exam, and if you take a look at the results for California accredited schools, you see a number of schools, their pass rates for each one of the individual schools. And I was looking at the overall passage rates, both for first-timers and also repeaters. I wanted to bring this to your attention that none of the schools, first-timers, none of the schools has reached a passing rate of 40% for first-timers. And for repeaters, none of them has reached a threshold of even 30%. In fact, based on the statistics that I'm looking at now, the overall passage rate for all accredited California schools is 23% for first-timers and 9% for repeaters. This result is horrific, and by that I mean I always want to question about the ability or our ability to continue to maintain the standard of all of these accredited schools, whether we have done enough to maintain the educational standards that we hold ourselves to. And looking at the scores, I'm not sure if we should consider certain policies to help the schools maintain or even improve their educational requirements. The Supreme Court of California is very clear about us working in tandem with schools to ensure that their credentials and their educational standards are maintained. in a way that is consistent with our policy. And in consideration of the amendment to our guidelines, and I know this is something that we talked about in the past meetings, I wanted to bring this concern to you and to everyone's attention as we continue to refine and improve our policy. What can we do to help the schools improve the results and the scores? Again, our passage rate is something that is important to me and all my constituents. And to that end, I don't want this to be hidden under the blanket, but I think this is something that we ought to think about as we continue to move forward.
Definitely, I think all committee members would echo sort of your wishes to partner with the schools. For many of those who were at the meetings yesterday, I think staff did a good job sort of providing a lot of information with respect that some of the schools can take back to some of their first year law school students. For example, the lab program, and I know Dean Mitch Winnick asked for some of that materials in both, I think, lab and as well as the state bar. He definitely wants to see all the schools improve. I welcome any other comments from other members.
I do want to make one quick note. This it seems like, I thought we were going to talk about it in the context of the subcommittee goals, but to talk about bar passage rates, it's not an agenda item under Bag and Keen that should have been noted. So if your suggestion was in the context of building or talking about the goals, I just don't know if we should launch into that discussion.
Alex, it's a part of the goals. So one of the things we have in here is item 2, and this goes to this issue, is consider reactivating the current suspension of guideline 12.1, and that is in the process of being done. And I think that is part of the goals, and Alex is right. This is an appropriate part of what I think Ed Standard should be on an ongoing basis discussing. Can we do more? I think that's something the committee and going forward should be looking at. And of course, I think we should all welcome the fact that guideline 12.1 is now back ready for prime time. So I think it's well within the parameters for the subcommittee to discuss.
It might be helpful just to give everyone a quick update on the status of the 12.1. So the schools are in the process of calculating and returning the report of their NPRs right now. So we provided them with 5 years of pass-fail lists adjusted for the current definition of the takers. We also ran comparison numbers inside in order to compare and verify what they report. Any discrepancy will be resolved before here at the committee. And at the next meeting, you'll be seeing those 5-year cumulative pass rates, as well as any resulting action that comes from that, or any sort of notice that we would like to give to those schools that may be above that 40% minimum, but approaching it. So that's the first step that's already planned, and additional steps can certainly be asking.
Any other comments on the goals? And then finally, in the open session, we have an oral report on the rule and guideline amendments allowing participant learning law schools to apply for California accreditation. Natalie?
Sure, thank you, Alex. So just to preview everyone, I don't have an item to share with you today, but I probably plan to bring an extensive one in the August meeting and wanted to prepare you regarding that. You know that the committee has been involved since 2013 in the process to look at a package of rule changes that began addressing 2 topics. One, a possible mandatory path to accreditation for all schools, the current registered unaccredited schools, and then a second, a path to accreditation for schools that have a fully online program. So just to give you some context generally, the ABA would allow up to 15 credit hours in an online format. They'll be discussing at their August House of Delegates meeting a proposal up to 30 hours. And the committee here is proposing to move to 100% format if the school should choose to do that. That would have California be the first state to do so. But it would be based on the set of the rules that you've already put together. They were created through the results of 2 working groups in consultation with general counsel, in consultation with a public working group, and extensive discussion with this committee. But you saw them as 2 intertwined proposals. At this point, the mandatory path to accreditation requires further action from the legislature and the court that has not yet been received. But we believe that those two proposals can be teased apart, and we can present to you a package that would allow the online project to go forward. So it will be the intention to bring the paperwork, the already settled rules that are already posted on the website in their teased apart form, and a plan to allow those types of applications to begin with the Board of Trustees approval in the fall. So are there any questions or concerns regarding what you know so far? I know you've been talking about it since 2013, so you might have asked all the questions by now.
So, just a quick question, Natalie. Again, can you just talk about that timeline again? You said it in the fall.
Sure. So we'll be bringing materials back to the committee at the August meeting, most likely to the Board of Trustees in September. That's when we think they'll be taking that up. And at that point, we should be able to release materials to the schools. And I do believe that quite quickly there will be a lot of interest from the schools to act on that new opportunity when it becomes available.
Great, thank you. And I believe that is our last agenda item, so we are adjourned for this subcommittee. Thank you.
Okay, so this would be the open session of the Moral Character Subcommittee. I'm James Epton. Let's do roll. Patricia Villalobos.
Here.
Good. We're going to do this again. James Bolton. Here. Alex Chan. Present. Dolores Heisinger. Here. Larry Kaplan. Here. Alex Lawrence. Here. Esther Lynn.
Here.
Bethany Beck.
Here.
Okay, we have everybody present. Thank you very much. So we have 2 items on the agenda. The first item is the moral character goals, which is attachment to C500. Which I know. So I don't know if everybody's had a chance to look at that. I have one question for Mark. In the ongoing number 5, review additional training for topics related to moral character determinations. Sorry, thank you. When and where will we have those? Will we have those at these meetings here, or we would have them separately? I'm assuming we would have them here in the whole committee for everybody to listen to?
Yeah, we would have them here, I think, prior to the start of the regular meeting. It's something like what you'll see number 4, there's a presentation by the Office of Chief Trial Counsel that's scheduled for August. Probably just calendar that before the start of the regular meeting.
And then would anybody in the committee of our examiners could then attend that, or anybody from the public could attend that over here?
Sure, absolutely.
Does anybody else have any additions or comments with regards to proposed goals for 2017, 2018?
I want to mention
Oh, if you want to do that here?
well, there was number 3 is a preparation of guidelines for consideration of UPL issues for use at informal conferences. Those have been drafted. I shared those with Jim for his comments, but they have in fact been drafted.
And Mark did a great job. I thought they were helpful to the whole committee. The one comment I was going to make to Mark was that my concern was not whether the applicant was giving an impression of not being authorized to practice law, but whether the public may have perceived that to be the fact. So I want to talk to you about that. But I think Mark will then circulate the moral character informal conferences guidelines to everybody for the whole committee to look at and go from there.
When's our appropriate changes?
So I believe that deals with the goals. And the next point is the oral report to the Board of Trustees. Oral report regarding the Board of Trustees consideration amendment to the State Bar Rules, Procedure 2302 regarding subpoenas.
Yeah, this is strictly an informational item. Just wanted to bring the attention of the committee. The Office of Chief Trial Counsel is proposing a change to State Bar Rules of Procedure 2302 to codify essentially a practice that's sort of already in use with respect to the issuance of subpoenas. And that also has some implications for moral character proceedings. What happens is that as all of you know, moral character proceedings are confidential, as are disciplinary investigations, but in the course of either of those proceedings at times, occasionally subpoenas have to be sent to third parties for information in aid of either a disciplinary investigation or a moral character proceeding. In those third-party subpoenas, it's customary, particularly under the rules of procedure of the State Bar, that a declaration be attached to those third-party subpoenas in order to inform the third party of the reasons for that, why we're asking them for whatever information we're asking them. There's some tension then because we have moral character proceedings and disciplinary investigations that are confidential, yet at the same time the rules require some disclosure of information to the third party so that they can, if they need to or want to, they can file a motion to quash and they can be informed of the reasons and then they can use that as the basis for their motion to quash the subpoena. So in order to sort of resolve that tension, it's been the practice of the Chief Trial Counsel's office to limit the information on those declarations attached to third-party subpoenas to just a minimal amount of information that's necessary. They don't identify the applicant, and that's sort of, sort of how we come to some balance between confidentiality and the right to know of third parties. The proposed change to 2302 of the Rules of Procedure essentially codifies that practice. This rule change was presented to the Board of Trustees, and it's now out for public comment. The public comment expires on July 31st. And, I've taken a look at it, and I've read the rules, I talked to OCTC about it, and I feel that the rule change is appropriate, and nor will it change the practice that's already in use. Also, I might also add that, with respect to moral character proceedings, the applicants sign a waiver and release that's pretty broad, and also permits, under that waiver, the right of the Committee of Bar Examiners or the Chief Trial Counsel to disclose to third parties information about their particular matters in connection with moral character proceedings. So, it's all fairly benign, but I did want the committee to know that this particular rule change had been proposed and that it did involve to some degree moral character. So I wanted you to know that. Yes, Dolores?
Question. So, the subpoenaing of information would not occur at the moral character informal conference level? No. So you're talking about beyond that, when there's an appeal by the person who gets denied and further information needs to be sought out, that's what you're talking about?
That's exactly what I'm talking about. During the course of an appeal, as part of that appeal process, there's an entirely new and robust investigation that's conducted by the Chief Trial Counsel's office in order to defend that appeal. And it's in the course of that type of investigation that subpoenas might be issued. Any other questions? No. Okay.
So I believe that terminates open session unless any committee member has something else they want to talk about. And I'll consider it done with open session.
All right, so we're going to come back at 2:20, about in 10 minutes, to closed agenda for the full committee.
All right, so we're convening the Committee of Bar Examiners full committee meeting. Let's start with roll call if we can, Kim.
David Forrest,
Here.
Angeli Agate,
Here.
James Bolton,
Here.
Robert Brody,
Here.
Alex Chen,
Here.
James Hefty,
Here.
Dolores Heisinger,
Here.
Corinne Gongora,
Here.
Karen Goodman,
Here.
Larry Kaplan,
Here.
Paul Kramer,
Here.
Alexander Lawrence,
Here.
Esther Lynn,
Here.
Bethany Pick,
Here.
and Patricia Villalobos.
And if I could remind everybody, because we're being webcast, please use your microphone when you speak, otherwise people cannot hear you. The first thing I want to start with is public comment. If we have anyone in the public area who wants to speak, please come forward. If not, we'll move on to the next item. Our next item is the clarification, alignment, and improvement of the work of the Committee of Bar Examiners, and that is Richard Schaffler.
Good afternoon. I'm going to introduce Richard. This isn't Richard, this is Sam. I'm Amy Nunez, Interim Director of the Office of Admissions. I'm going to start out the session and also introduce Richard Schaffler, who is going to be authoring the final report that's going to the board on the full Appendix I review. So this is a review of all sub-entities that report to the board. So with that, perhaps Richard, can you introduce yourself and give us a little bit about your background?
Thank you, Amy. Thank you, everyone. My name is Richard Schaffler. I am here at the bar working solely on the Appendix I report, as it's poetically known. I spent 5 years in the California court system as research director and 15 years as the research director of the National Center for State Courts in Williamsburg, Virginia, which works nationally with all 50 states and abroad on court management issues. In the course of that work, both in California and around the country, one of the constant issues that we were addressing was the relationship between the organizational structure of courts, either at the state level or in the case of large urban jurisdictions, the local level, their governance issues and their organizational performance. So that experience is helping me help you sort out some of the issues that have been raised by the task force on governance in the public interest. And so what I've been doing since being here at the beginning of March is to get up to speed on all of these sub-entities, what they do, read all the background material. I've been meeting with staff, been meeting with the sub-entities themselves, been meeting with board of trustees members, with bar management, to try to pull together the information needed for the decision makers who are going to decide, which is to say the board of trustees, on how, well, for each of these sub-entities, the threshold question is, should the bar be doing this at all? If so, what is the best way to do that? If not, what is the best, and the function is valuable, then what is a better way to do it than from inside the bar? And I think the first step in that has been to try to create an accurate and complete picture of what each of these sub-entities does. Understandably, there is a very wide range of activities that the bar sub-entities engage in that range from adjudicatory functions with mandatory fee arbitration or the client security fund to things like you've been discussing, accreditation, licensing, and so on. So there's a wide range of those things, and there's uneven information inside the bar as well as outside as to how that work is actually done. Is it done by the committee? Is it done by the staff? What is that division flavor? Is there an effective use of technology, if that's appropriate, for getting that work done efficiently and effectively? And so I've been working on, first of all, assembling the facts about each of these and getting those reviewed and vetted by those who are engaged in that work, and then trying to create that sound empirical foundation for the policy questions then about how that work should be done. And there's really two sets of questions. One is the governance piece, which is what is the best way for this sub-entity to connect to the rest of the bar and the Board of Trustees from a governance perspective, from a management reporting perspective, what management information should be being reported from that sub-entity on what frequency, so that the bar Board of Trustees can honestly claim that it is effectively managing the bar. And then the second set of questions revolve around how is the work being done? Is it all regulatory agencies seek to make use of the expertise and practical knowledge of the experts, the subject practitioners, those whom they are charged with regulating, for perhaps obvious reason that those are the people doing the work. They want to be sure that any regulatory policies, rules, etc. that are developed are informed by real-world practice and thus make sense and are done in a way that will assure effective compliance with those. And so the question is, what is the best way to do that? So I've been looking at both bars around the country and how they do some of these very similar functions, and as well as looking at other regulatory agencies in California in general, in terms of how they conceive and carry out their regulatory functions. And it's apparent at a glance that a few things about the legal profession that are, in the way that it's regulated, are different. If you look within California, for example, you will see that while the bar conservatively makes use of 155 plus 96, call it about 250 volunteers across a dozen odd sub-entities. The nearest comparison to that is the Medical Board of California, which regulates the medical profession, which makes use of 40 volunteers, and then the next two highest after that are nursing and the architects, but anyway, it goes down to 27 and all the way down to as few as 3. Partly that's because in some cases they're doing very similar things, in some cases not, but it's just to say there's a very large universe of entities and volunteers that the bar is trying to make use of, so the governance of that is complex. I think it's also fair to say that over the years, this governance is a two-way street. No one thinks that anyone's been doing anything through ill intention or being misguided, but there's been a disconnect between what entities are doing and the extent to which the Board of Governors and Trustees has been aware of that, and vice versa. And so that's the issue that the task force posed, is the need to get these things aligned, connected, and better understood and commonly understood, so that the bar as a whole can be sure it's moving in the same direction. It's slightly useful, but not ultimately always instructive, to look at what other bars around the U.S. are doing for a couple of reasons. There's a couple of different flavors of bars. There is the mandated, you must be a member of the bar to practice law. There is the voluntary, you can if you want version. And then there's we put both those two things together. And that has, as the bar has already articulated for itself, that created somewhat of a contradiction between its regulatory functions and its trade associational functions, or promotion of the profession. So licensees on one side, members seen another way, and that's the other piece that's being pulled apart to focus on the regulatory role of the bar. The other reason why it's not always instructive to look at others is that California is different. Sometimes California, I say this as a born and raised in Long Beach guy, California sometimes says we're different, and that's a meaningful statement, and sometimes California says that because we're big and proud of ourselves, and in fact, we're just like everybody else, and if we kind of be willing to admit that, we could learn a lot from the other experience of others. And I think there's elements of both of that in any institution in California. And if you look at the sub-entities, you can see that some functions, like the Client Security Fund, are done very similarly across the United States. They all have a committee of 5 to 7 volunteers and public members, with a slight majority of attorney members, and they all carry out a very well-defined function in largely very similar ways. And then you get to some other area like access to justice, and that's very wide. Our lawyer assistance program, very wide range from telephone support, peer counseling to actual rehabilitation. So, which the right solution for California is, of course, a question that's every one of these sub-entities is posing for itself in this review, and that the Board of Trustees is also trying to get a handle on. So, the Committee of Bar Examiners has the bar engaged consultants Elise Walton and Elizabeth Parker last fall to begin this review. They met with various of you and with your working group and developed the report that you all had access to and seen, that contains a number of recommendations in different areas that Amy has framed in the memo that was prepared in advance of this meeting. So I'll turn this back to Amy for that.
Great, thank you. So where we are today and what the goal of today's discussion session is the following. So at this point, the committee has received the table that summarizes the areas that we're going to explore and look at in these recommendations, or recommendations for each of those areas. We've also attached a copy of Elise and Elizabeth's report, as well as Ms. Parker. That report contained recommendations that have also been incorporated in the table. And we also included a legal opinion that was prepared by our Office of General Counsel. These documents together, we hope will formulate and prompt discussion today. And the idea is that we are hoping to walk through this, the areas of licensing and corresponding recommendations to those, and to gather everyone, the CBE's response, reactions that can be incorporated in the final report. So our feedback that we collect today will be going to the program committee meeting in July, and will get and eventually get incorporated in the final report that's due in September. So with that, we will start looking at this table. So in terms of gathering feedback, there's 2 ways that we can do this. We're going to walk through. Richard is going to collect as much information as we're going through right now. That could get feedback incorporated into the final report in that process, or we could also have the committee submit a formal letter separately if that's an option we'd love to exercise, but it's ultimately up to the committee. Yes. Okay, great. All right, so let me talk about how we've organized the recommendations.
Well, Amy, before you start, I'm just curious, so there's 3 attachments. There's the legal analysis by OGC, and I'm wondering if the committee would find it valuable to have Dustin provide a brief overview of the legal framework, because I think that's an important initial sort of threshold matter, is to understand the legal construct in which we're operating. Then there is the Elise and Elizabeth report, which begins to review the different functional responsibilities of the CBE as they currently exist and makes recommendations about possible changes. And then the final attachment is really staff's reflection of all of that work, the legal analysis, the Elizabeth and Elise report, trying to codify that into a new delineation of responsibilities between CBE and staff. So I'm just wondering if before we jump into the table, if the committee would find any value in at least hearing briefly from Dusty about the legal opinion, or at least being given the opportunity to ask questions about either of those
Well,
things?
I'd also like an opportunity to weigh in on Elise and Elizabeth's report, because there are some inaccuracies in her report as to what transpired and some of the representations that were made.
Okay.
So we can start with Dusty.
Okay, the memo came about because when Erica and David first took their new roles, they had requested an overview of the different authorities, and then when in light of the whole Appendix I, it made sense to lay out the different roles and responsibilities and oversight of the Committee of Bar Examiners. So first, the Supreme Court has the inherent authority over the admissions functions, and that's both in case law, in the in re attorney discipline case, and then the Supreme Court has adopted various rules of court that express this as well. One of the recent rules that was adopted also mentioned specifically that rules that are adopted by the Committee of Bar Examiners that are then approved by the Board of Trustees must be submitted to the Supreme Court for review and approval. All right, I think most of you also know that the legislature enacted the Business and Professions Code 6046, and that provided that the board may establish an examining committee having the power to examine all applicants for admission to practice law, to administer the requirements for admission to practice law, and to certify to the court those applicants for admission. Of course, the Board of Trustees did establish a Committee of Bar Examiners, and here you are, and those are the primary duties that have been set forth in the legislation. You also, as a committee, have the ability to adopt reasonable rules and regulations subject to the approval of the Board of Trustees. With regard to the Board of Trustees, the State Bar is governed by the board. The board has the executive functions of the State Bar, and the board may formulate and declare rules necessary and expedient to carry out the State Bar Act. The State Bar has various rules that it has adopted. Rule 6.20 requires or states that State Bar committees have only the powers and the duties and the authority delegated by the Board of Trustees. And Rule 6.21 also states that the committees, if they act or speak, it must be on behalf of the board and subject to the board's approval. Okay, so the questions that came up, the first was, what can the Committee of Bar Examiners decide on its own? So basically, the role of the Committee of the Bar Examiners is to administer the admissions functions to the extent authorized by the Board of Trustees and subject to the ultimate authority of the Supreme Court. With regard to what is reported to the Board of Trustees, the Committee of Bar Examiners must provide status reports on activities that are pertinent to the board. And so under our current structure, the Committee of Bar Examiners status reports go to the Programs Committee, and then the Programs Committee reports to the Board of Trustees. With regard to what must be approved by the board, the authority lies with the board to approve any acts that the Committee of Bar Examiners determine, I think I said that wrong, I'm sorry. Basically, the board has the authority to approve what the Committee of Bar Examiners does. And then the fourth question was about legislative approval, what requires legislative approval. So this is usually pretty clear. The legislature usually states in whatever the various statutes are what authority they are granting and what they require. For example, this year they enacted 6046.8 that states that the board is to oversee an evaluation of the Committee of Bar Examiners to determine if it properly tests for minimum competency, and the board is required to report as of March 15th, 2018, and every 7 years thereafter. And as you all know, the Committee of Bar Examiners will be involved in those reports, but ultimately it will be the board's responsibility to respond to the legislature on that. And then finally, what requires Supreme Court approval, and that would include all rules adopted by the Committee of Bar Examiners, the admittance of applicants who fulfill the admissions requirements. The Supreme Court appoints 10 of the CBE members from a list of nominations that comes from the Board of Trustees. And the Supreme Court also will approve any recommendations proposing any significant changes to the bar exam or the passing score. So that's a quick overview of what was in the memo. And if you have any questions about that, let me know.
So I have a question. I'm not sure which is the right time to ask this. Procedurally, we just did the swearing ceremony. The Supreme Court basically grants a motion to admit our admittees. And is it the CBE that makes that motion?
Yes, and the recommendation that these people have met the qualifications that are required in order to be admitted.
So that motion comes from CBE, not from the Board of Trustees?
Yes.
Okay. Now, typically, the people who are on that list are on that list because staff has said they passed the bar exam, they've gone to the right schools, and they passed moral character. But occasionally we say on certain people, we pass on moral character before staff can put them on that list. Is there some kind of informal rule that says staff can put people on that motion list without this committee approving them in most cases, and then only on the cases of moral character questions do we get to decide who's on that list? So I'm trying to figure out how the system works.
Well, in order to get on the motions list, applicants for licensing have to satisfy all of the criteria in order to move forward. So that we would never put anybody on the motion was not been clear. That was moral character application is not been clear.
But in most cases, staff clears, we don't clear. Sure.
Yes.
90-95%.
Yeah.
So only occasionally do we say, does the staff say, we want CEB to approve these people, and then we approve those people, and then assuming we meet all the character, other qualifications, they go to the list.
Yes.
I think Mark touched on that. Oh, that wasn't to you, I'm sorry. Yesterday, when we were talking with the law schools, you know, there's certain review levels that go through, and if they passed the levels upon staff review, then it's not necessary to bring it up for further discussion. Am I saying that correctly, Mark?
Yeah, I mean, the majority of cases are cleared by cleared administratively. I understand that that's literally the application of the CBE. So certainly if an application were to be denied, that's only the committee is going to deny that.
Is there, the reason I'm asking all this is it comes back to the goal of the CBE and or the purpose of the CBE. The CBE basically is the one who says, here's who we put on the list to go to the Supreme Court. When people start taking away the power or the authority of the CBE, does that affect whether or not we want to make that motion or whether we should be making that motion? So if you take away our control over moral character, then should we still be making that motion or someone else be bringing that motion? I don't have the answer to that. It's not that I want to raise. That's just sort of. Sorry, thank you.
So what I think is important to kind of take away from the OGC analysis and how it really ties to the discussion that I hope you all have is that although this has not been done in the past, to my knowledge, the board is responsible for affirmatively delegating to the CBE and affirmatively asking or deciding upon what it is it's going to ask the CBE to do. The CBE, according to the legal opinion, does not have independent authority. It has the authority granted to it by the board. The board has not heretofore taken action in that vein. So now, ultimately, we will be asking the board to do so. And to kind of guide that discussion or ultimately those recommendations that go to the board, we have some material. We have the Elise Elizabeth report. We have this matrix that's up on the screen in terms of staff's proposals for what would be delegated to who. But I think that's the important kind of takeaway from the legal opinion. And your question is a really good one. Because CBE has made that motion, but that doesn't mean that it needs to continue to be that way going forward. And maybe that's a legitimate, change to make. But that's precisely the kind of question that's implicated by this analysis.
So Eric, I have a comment on that discussion that I think is more from a historical point of view as to having sat on the Board of Trustees when the proposal for the 2-day bar exam first came forward. It wasn't as if this committee had bypassed the Board of Trustees and submitted simply to the Supreme Court, we want to change to the 2-day bar exam. They came to us. The chair came to us with a presentation for the reasons that they wanted to do it. And we didn't think it was right. We thought we were concerned, as I will continue to be concerned in my very last few meetings with public protection. I was very concerned with the Office of Public Protection. So, I mean, that assumption that we've operated independently of the board, I don't think that's based in at least my history. I'm certain, I look around the room here, for this group, my history with the board predates anybody else that sits in this room currently, and it's not been true. We've had a good working relationship, and I do appreciate the report by Desi. I do think it clarifies things. I think there have been in his history, because I do have the benefit of prior confidential attorney-client communications and reports by lawyers working at OGC previously, that would certainly have a different analysis. But I don't think, as far as the role, and I'm privy to reports that clearly make it clear that we are responsible for the administration of the exam, but I don't think there's anything inaccurate or legally unsound by the analysis as the relationship between the committee and the board. But I do think the idea that we haven't done that before, I do think that's incorrect. Actually, so.
And I believe David also was on the board, if you have anything to add.
I remember that clearly because I was a liaison to the CBE at that particular time, and also the chairman of the Admissions and Education Committee. But that was originally presented, and I think the Board of Trustees did send it back for further examination. I do recall the CBE conducting a thorough hearing with psychometricians, and then once they conducted that hearing, they did again present it to the Board of Trustees, and at that time we were satisfied. So we did have a very robust relationship with the CBE at that time.
Yes.
If I can just comment generally, I think this exact issue about what's the role of staff and what's the role of subject matter experts is one of the things that exists across the different sub-entities. And I think part of what I've been asking about in meetings is because that division of labor where the business rules and decision rules are clearly articulated and developed by the subject matter experts of the sub-entity, then the staff can implement those and thus only rely on the expertise of the sub-entity members for the exceptional cases, the complicated, the ones that present new issues of fact or law that aren't, whose solution is not obvious. It's the staff's job to think about, perhaps propose different options in that case. But that's where you really want the expertise of people like you in these different sub-entities to come to play, not to rubber stamp. That's not a good use of your time. If the decision rules are clear, and to be clear, that makes sense when those decision rules are essentially a codification of how these different sub-entities have been operated. Some sub-entities have those written down. Some of them it's in people's heads and understood, and so that's the way to guarantee sort of consistency, fairness across over the years, is to have those precedents kind of documented and used, and to rely on the staff to identify exceptions. So that's been an issue across many of these sub-entities.
I actually think that's a good segue, so I'm gonna, if it's okay, hold that thought. Don't forget it. Or okay.
Well, Karen actually succeeded me on what is the Board of Governors, and just to the extent that people are reviewing their experience.
Okay.
We really didn't have any issues that I can recall with CBE during my time. It was pretty much, we thought they were doing an acceptable job, and we left them to do it. And there was quite a degree of trust, but there were no real issues, for whatever that's worth, historical perspective.
Thank you. But as a segue, when we get into moral character, I think that's where there is a problem, because when we have informal conferences, those aren't easy questions. Those are difficult questions, and that's why I think the committee really has a problem with staff handling those. So I think we can segue back into the report.
Okay.
And on page 12, it says CBE working group recommendations. First off, the CBE working group was CBE members and others. And I want to make that clear to the committee. It wasn't just David, Larry, and me. So when it says CBE working group, it doesn't mean that the three of us said all of the stuff. Another thing is on page 12, under size and structure, we, the three of us, did not agree to reduce the size of the CBE. If anything, when it says a smaller CBE will make it easier to convene a simple majority quorum, I remember Larry saying, well, I don't see why that, have we ever had a problem establishing a quorum? That doesn't seem to be an issue. We never said that it would be necessary to reduce the size of the CBE. So I don't know where this came from.
So, can I follow up on that, because I did actually have a conversation with Lisa about that particular line, because I was one of the people on those calls that Erica was alluding to with David and Larry and herself, and so that was my memory too from that working group call, that there wasn't an agreement on that, and I actually raised that point to her, and she said, no, what I'm referencing here, and if you see the reference, it's to the full CBE meeting that happened in early February. That was a meeting that I wasn't at because I was ill and wasn't here that day. But what Elise was describing in that part of the report was her impression of what she felt the entire CBE had discussed at that meeting. So that particular line actually deals with that. So when she refers to the February 2 meeting, that was full committee.
So that refers to this footnote 20, where it says it should be noted that the February 2 CBE discussion conversation generally accepted these recommendations.
Yes, she was talking about that meeting.
So that's supposed to be all of you. Generally, if you read these recommendations, they're saying that all of you generally accepted these recommendations that are listed under 1 through 4. If you recall these, I don't know if you were, this is why I told all of you, you need to read these and you need to review them, because I don't remember these being recommendations, at least that I thought about. That under the next page, 13, 4E, pending study about the original reasons for creating both LSC and RAC, consider combining both into a single organization. That's something, okay, well, it's something to think about, but what we specifically also said was there was a reason, there was a specific reason why there were two different groups. And that's something that RAC needs to talk about. That's a RAC decision. That's not something, we're not gonna willy-nilly decide, oh, let's just combine them both. So I don't know how that got into a recommendation that we're making.
Yeah, I think that back then, there were a lot of members who were quite new to the committee and didn't realize how this committee functioned. I remember when she said that Ms. Walton mentioned that some folks had mentioned that this committee could be smaller. I told her, I don't think this committee can be much smaller than it is. This is a huge committee, but everybody has a function. If this committee was a lot smaller, I don't see how we could get the work done. We need a committee this size because of the number of subcommittees that we have, and the subcommittees all have specific duties to do, and we are all busy in our particular subcommittees. So, and I gave her several examples, such as moral character, examinations. I said, every one of the committees that I'm engaged in, everybody's busy, so I don't think that a reduction in size would be beneficial to this particular committee. Maybe some of you may have said that, but not really necessarily at that time having any full knowledge of the committees. But again, this is why Erica mentioned that you should at least take a look at this study once again, now that you have a better grasp of the committee and what the subcommittees actually do.
My point is it's a misrepresentation. It is flat out a misrepresentation, because also February 2nd, there were people who that was their very first meeting. And to say that they're saying, oh, these are our recommendations when it's their first meeting is ridiculous.
Okay. So we are hitting some of the topics that are in this table. I think in the best interest of time, it's probably best to go through the licensing functions and the recommendations individually. Governance and size of the committee is embedded in that, and we can capture that. But it doesn't mean that we cannot collect information or feedback. I don't know if you want to do the report feedback in written form, and it sounds like we really want to get to the recommendations, and so we'll capture it. We'll capture this as we go through each meeting.
I just want to say, just flat out, these recommendations are not our recommendations. They're not.
Yeah, and I want to tell you, and I'm not going to use the word what I'm thinking, which is all due respect, Amy, but I will say I'm thinking that I really do think we need to have a fair and robust discussion on the issues that are of concern to our committee, because this report directly addresses the function of the committee. And I think Erica's point is extremely well taken, because when I read this report, and then it was explained to me by Richard yesterday, the long part indicates this was areas that the working group, our three representatives, Larry, David, and Erica, had assented to. I was very confused, because with the existing functions of this committee, it's not conceivable to reduce the size. Now, I recognize that there's certainly some people who would like to see the size reduced. Probably some people would like to see some of us off the committee. And certainly would like to see some of us not as vocal about things that are going on. I'm not going to not speak out. But I will say that to represent it to be one thing and not is not accurate. And I think there should be a discussion amongst the committee as to whether the committee thinks it's too large of a committee. We've never had a problem with quorum. I sit on many boards where we do have problems with quorum. So does the committee thinks that it's too big? That's something I think we ought to raise that issue right now.
Well, if I could see, that's exactly the point today. The report that you have in front of you from Lisa and Elizabeth is one of the inputs. to the full Appendix I report that we'll be presenting to the Board of Trustees. The point of today's discussion is to go through the various pieces, whether it's the size of the committee, who does what on moral character, who does what on accreditation, to go through each of those things and to secure the input of the full CBE, and that's what's being reflected. I'm taking notes, Richard's taking notes, Amy's taking notes, Leah's taking notes on all of that information, so we can reflect, here are recommendations, and here are the committee's responses to it. The Elise and Elizabeth report is an input, and I'm sorry if you don't feel like it is an accurate reflection of what was said, but that is not being taken as gospel on what the committee said. So that's what we're here to collect today.
And the governance issue, for example, is the first area in Table B of this attachment 3, the number, the size of the committee of bar examiners. So going through the table, as Amy suggested, the committee will be able to hit all of those issues.
I just want to hit one more because I think it's really critical, and that is on page 25 of the report, under CBE Working Group Recommendations for Accreditation. Very specifically, I said several times, not only, well, didn't say several times that accreditation should not be outsourced, but we said that RAC should be included in this discussion. And I don't see that anywhere on this. I see the audit, I see this audit should begin in 2018. I don't remember ever saying that. I don't remember coming up with we didn't come up with a year. That was probably come up with, and we said, okay, sure, why not? That sounds good, but it was always, since it's not our expertise, that was something that should be discussed with RAC. That's RAC's expertise. And RAC is not here anywhere. It should be. And there's really not any excuse for that. So yes, we can move on to the table.
Yeah, I want to take a step back because I think we can end up getting really bogged down unless we're going to stay as at 10 o'clock tonight. So let me ask, I'm going to ask a couple of questions because I think everyone should know what's going on. Question number one is, what is the process that you envision for what happens? In other words, there's a certain set of recommendations that goes to the Board of Trustees. And the Board of Trustees adopts those recommendations. And are they reviewed by the Chief Justice of the Supreme Court, or that it's within the Board's authority to make changes, either size or duties and responsibilities, etc. And then there's some stuff that needs a legislative change, correct?
Yes, there's absolutely things that need legislative change. There would be things, depending on what actions the board takes, there would be things that require legislative change. There would be things that require rule change, process changes, not just related to CBE, but related to a number of the sub-entities that are being studied here. So the process for the CBE Appendix I review, at the July board meeting, we'll be making a presentation to the Programs Committee, which Joanne Mendoza is the chair of, to talk specifically about, to go through a similar presentation where we'll be talking about the function chart that you see in front of you, getting input from the Programs Committee on that. It'll be, the plan is actually to provide them a copy of the same report that we've given you. And they will hear that information, they'll give input back. That input will include, what we will tell them will include the discussion that we hear today. All of that information, the discussion from you all, what we hear from the board, will find its way in. It'll all be another input into the report that Richard is ultimately pulling together to go to the board. That written report goes to the board at the September meeting, at which point the board, we expect, will act on all of the recommendations that are in the report, looking at, again, the recommendations from staff,
the perspective of each of the sub-entities with regard to their role, and we'll make a decision. And at that point, yes, we would figure out what needs to be done statutorily, regulatorily, and proceed to make those changes.
So there'd be an action plan that comes out of that?
Yeah, I would imagine there would have to be quite a voluminous one.
Okay. And so it would be, so it's basically up to the board. And it doesn't necessarily have to be approved by the Supreme Court or the Chief Justice or any of that. It's sort of an operational operation.
Well, I think as Donna indicated, certainly any changes to rules of court would need to be approved by the court. We are in very close communication with our key stakeholders, which include the Supreme Court as well as the legislature. And so I think what I can say is all along the way, with respect to all of these reviews that are going on, our stakeholders are kept up to speed and informed. And so while there may not need to be formal approval of each and every change, there certainly is ongoing dialogue, communication, and feedback. And I, as the executive director, would not take anything to the board for consideration that was proposed by our key stakeholders. So I can say that with confidence here.
And then, okay, so then our role today is to go through each of these recommendations. So the report that we're seeing is basically three pieces. One of them is basically the report from the consultants. Okay, and then the other one, and then this thing is kind of the staff's, what do you call it, implementation. They're taking all these pieces and putting it into kind of like a workflow or a flow chart. So our role today is to go through each of these pieces and basically say, we hate this, we love this, you know, we're do X, Y, and Z. Okay. Now, this is not quite at the same level of reorganizing the federal government, but that's a lot of stuff. So, how much time do we have, and how do we put it into bite-sized pieces to manage the flow of it? Because there's a lot of stuff. You know, and so.
Why don't I describe how this has been organized to start? So we started by looking at licensing functions for other bar jurisdictions and bar jurisdictions in general. So if you look, it's been categorized by, for example, exam development. So these are the key areas. We also have exam analysis and review, such as the bar exam studies that we have taken, California State Bar undertook. We also have moral character. We have testing accommodations. I'm just giving you the overview of the functions that are typically carried out by a licensing agency. Eligibility and policy development, and we talked about that in the context of Chapter 6, which also the Chapter 6 violations, which includes enforcement. For California, accreditation, trends in licensing and maintaining relationships with legal institutions have been incorporated in here, and that is institutions including the like law schools. And we've added budget and personnel just to clarify that for the CBE. So why don't we start with exam development? So under exam development, the essential tasks that fall under that function include the development of questions that is currently carried out by the EDGE team, and that the recommendation is for that to remain the same. This table also includes the statute, the rules, or the legal opinion that impact each of those functions. So the other is review of questions. Currently that is a function that's carried out by the CBE. We do that twice a year, and the proposal here is to keep that the same. The review and evaluation of the grading process, that would be carried out by the CBE, and that's relatively new, and it's not new in the sense that you get to see the policy. So you developed the policy, but I think this is a method for us, and it stems from a recommendation of the Elise and Elizabeth report that we conduct more reviews of our policies. exams on annual basis or semi-annual basis. The review and evaluation of the process itself is not new. It's just formalizing it so we do it within specific time frames. A sampling plan to determine exam content areas. This is, again, a function that's carried out by licensing agencies. This would be with the staff, and staff probably in consultation with our psychometrician, and this is really looking at the content areas of the bar exam, from one bar exam to the next. The next includes the challenges to exam questions. So we have seen this where perhaps a student, we saw this not too long ago, a student challenged a question that appeared, whether it was a first year exam, I think, or a bar exam. This would remain with the CBE, so it would come to the CBE, and that stays the same, as well as setting exam fees. On occasion, the board might ask the CBE to review its exam fees and make recommendations for potential changes. This would stay with the CBE. All right, so now we're moving to exam analysis and review. Oh, sorry. Sorry, let me stop there. Does anybody have any questions, concerns, areas of clarification under exam development?
Before it gets there, I just want to clarify one other thing about the table. There's a missing column, which is board oversight. And so the idea, just going back to the process, once this kind of functional responsibility is finalized, then the next piece will be, and what does the board need to approve? So whether staff does it or the CBE does it, what then also necessarily must come to the board for approval, or what can be effectuated by the CBE alone or staff alone? So that's kind of the next column that we're not tackling today.
Amy, can you articulate a tad bit on number 4 in the sampling plan?
Yes. So licensing agencies that develop bar exams or exams in general need to control and examine the questions that appear on each exam. So ensuring that there isn't repetition, or that there is no rhythm to the question areas or topic areas that appear on that exam. So that's usually controlled by a psychometrician along with staff. So that is what that involves. Currently, we do have a process for that. If you want to talk about that, Lisa.
Yeah. So I just want to also add, in terms of number 1, the development of the questions. There's also the performance test component, and the performance test is developed by the drafted and developed by the performance test drafting team. So I just want to add that to that number 1. In terms of the sampling plan, we do keep a spreadsheet of, and the committee sees every time there's question selection, and the EDGE team has every time they recommend or nominate questions for selection, is that it's just, it goes back 10 years, usually you see about 8 years, and it just sets forth every single subject that's been on every single exam, so you can see cross-referencing, what we've been testing.
Which is my question. I remember the spreadsheet. I see that twice a year. What's the difference between that and our spreadsheet? Because we do have a good historical basis. We had Dennis, and now we have
Dave Kelly.
Yeah, Dave Kelly. How does that differ from what we have now?
So I think it's examining that with an eye for whether it conforms to the methodology that's typically employed with exam development.
And it's having it be assessed by some kind of psychometric expert to review over time, are you truly implementing the exam content with fidelity to your plan? So I think it's a little bit different than maintaining a spreadsheet and having staff or even long-time volunteers looking at it. It's a bit more of a rigorous and independent process. So it's contemplated. This was actually a recommendation of Chad Buckendall from last year's standard 7 study, content validation study.
So it does sound like it's a little inaccurate to say that staff's going to do that, because it's not to do what Leah says would require a true specialist in the field. That I don't think at this point we have within the city staff. So when it says, I think there would be to better clarify, staff and outsourced psychiatrician.
Well, if you recall, we've talked about this where Ron B. is working closely with Roger Bolus. He is performing some of the work. Roger Bolus is our psychometrician now. He has been working with him to transition and help us with some of the analysis that is conducted typically with the exam. So we do have staff that can help address this and perform some of these functions. So it might not be staff in admissions, but it is state bar staff that we have.
I don't think Ron's a psychiatrician.
He's not.
It could, the note could be staff with consultants as support. That's it.
Yeah, I think that, I just want to be accurate. If we're going to have a clear proposal, I think it should be accurate.
We would use that.
Also, when it talks about content, we also talk about what areas you're going to be tested. I mean, if you go back and say, okay, we're going to drop trust in states and we're going to add criminal procedure, whatever. Is that a decision the staff should be making or the CEB should be making?
So that'll be in the next section, where we talk about the.
This is assuming the existing exam subject areas and the sampling plan is applied to existing exam subject areas. In another section where we're going to talk about the studies of the bar exam that we're now required to do every 7 years, that's when we would address, do we drop or add subjects?
Okay, thank you.
May I ask one more question? Has Dr. Bolus, Mr. Pye, and Dr. Wilkendahl prepared or drafted a protocol with respect to the sampling plan so that we can at least have an idea of what they're doing or how they're approaching this particular plan?
We haven't moved in that direction. We are in this preliminary stage of reviewing these recommendations.
Is it too premature to request that Dr. Bolus provide some type of presentation to the board on that?
All right, so the next area is exam analysis and review. And this refers to any analysis that's required for the bar exam specifically. So here we talked about standard setting study, content validation study, the upcoming job analysis. And this would specifies that the CBE would participate as a working group that would be convened in the manner that it was for these other two exams. So this would be a function that's carried out by staff in consultation with the CBE. Any questions?
So going back to my last question about content, determining exam content areas, you're saying that really would fall under the content validation study, but I don't really see that being clear from using the word content validation study. So assuming this is going to be something that somebody's going to look at 5 years, 10 years from now, we're basically writing a letter to the next CEB committee or two, I think it needs to be clear that the content validation study includes changing areas of study or areas of examination, so that's where that point is being addressed.
Comment. This seems to be reducing the CBE to inputs into a work product that is controlled and decided by staff and consultant, much like what we're doing right now. And obviously, some of us are not real happy about that. Why wouldn't, being a rather major policy question, why wouldn't this at least be routed through the CBE to the board?
So as I indicated, there is a column missing for the board. This is a clear example of an entire body of work that necessarily will be approved by the board. These studies need to be submitted by the state bar to both the legislature and the Supreme Court. And so when the next column is added, staff with consultant support, approving entity is the bar's board of trustees. So I think this is somewhat misleading as it's currently structured, but not
Okay,
in
well-
a negative sense. We just don't have the board here. So the role that's been identified by the CBE is to participate on an oversight working group. I think your recommendation would be that the study results need to come first to the CBE for review, comment, and then submission from the CBE to the board, which is feedback that we can take and
Yeah,
take note of.
the CBE should be one column to the left, or is
Can I also suggest that maybe a way to help us all make sure we understand the process is that we, and I've done this with other sub-entities, so I'm going to collaborate with Amy and others, to make a flow chart of what is the process for exam development modification, because then I think we can see, when you see it done that way, you can see, oh, if it goes this direction, it goes to CBE, if it goes this direction, and we can, and then it's a faster way, I think, to get clearer on what the process is, so we can try to draft that, if that would be helpful.
Any other thoughts on the analysis or review? Okay. The next function is moral character, and this is two processes. So one is the reviews of the applications themselves, any informal conferences. The recommendation here is that staff oversee that, which is a change to the current process. And then denials or appeals stemming from denials made at the first phase would come to the CBE, which is how we operate today. Any thoughts or comments?
So is this proposal basically the committee of our examiners would no longer be doing informal conferences at all, that would just be dropped entirely?
Yes.
So issues with respect to rehabilitation and everything else would still be decided by staff. And essentially staff would say, this is something that should potentially let the trial counsel litigate this with the state bar court rather than this committee deciding whether or not somebody would litigate the state bar court.
Essentially, we would only get appeals. We would only get appeals.
But would somebody have to appeal before they could go to state bar court? I would presume that would be the exhaustion of the
They have to
administrative.
Right. So if there was a denial of the moral character by staff, then the applicant would appeal to the committee of bar examiners, who would then take a look at it and say, no, we agree with the applicant, you should have been admitted. Or we agree with staff, you shouldn't be, and then it would go like it normally does to the state bar court, and OCTC would defend the decision.
Okay, so for me, that raises a fundamental question, which is, what is one of the purposes of the committee? And I see it as, at some level, and especially with regard to public members, it is to be I may not like the term, but a check on staff, and or a safety valve to make sure that the values of the greater whole are being properly applied. This would make it so that some staff decisions on tough cases or close cases to approve moral character, make a positive determination, would never be seen by this body. And so it is, to the extent that is an important purpose, it would be diluting that.
There are some people who would appeal. There are some people who, not everybody's going to appeal who could appeal, is what I think. And that goes to your point, I think.
Well, there's enough at stake. I think most people would appeal.
Well, they shouldn't have to, though. I think, I think I brought up before, leaving a decision on a close case to one person when we've had cases where 3 people have a problem deciding and it has to come to the full committee, that's a problem.
Yeah, I tend to agree with that.
And it's also, there's a reason why we have a public person and attorneys involved in making those decisions. But, sorry. Anyway, go ahead, Laura.
I agree with Paul. my recommendation would be to raise the threshold of the moral character applications that are reviewed by staff to minimize the number that go to the moral character committee, not do away with the moral character informal conferences involving staff, but reduce the numbers so that fewer committee members are needed to review. That would be my recommendation, not to do away with the participation of committee members in informal conferences. I agree with what Paul said. As a public member, that has been one of the most valuable things to me, participating on that committee, meeting face-to-face with applicants, putting a face to all the applicants that we that pass through our committee.
Very nice. Okay. I think that the benefit of having actively practicing attorneys performing the informal conferences is something that can't be replicated or replaced regardless of the amount of training that you would give to a staff member. Because a lot of the issues that do come up in the informal conference, if you've never had the context or experience of being in a law firm or a legal office or kind of going through some of the similar experiences, your decision making is not going to be as fair as it could be. And I think that it will be doing a disservice to the applicants themselves to eliminate that that input of having people that are actually practicing and actually dealing with these issues on an ongoing basis.
Question. Would it be accurate to say that this proposal kind of replicates the way it's currently done with examination accommodations?
Exactly.
Okay. All right. So everyone should think about that. Okay. You all know how it works. I'm trying to kind of get some context to this thing because otherwise it's way too fuzzy. We all know how the accommodations with exams works, right? Which is basically staff decides if somebody's going to get accommodations. Then if they don't like it, they appeal, and then we end up here.
Of course, with accommodations, it's not quite as fuzzy. You don't have things like people with, a crime they committed 5
Right.
years ago.
I'm not getting into whether or not that's a good idea. I'm just trying to explain to people that this is what we're talking about. Okay. Second question I would have is, right now the way moral character works is staff pretty much does make decisions in terms of what's going to get bounced up to the committee already. So what this kind of does is it raises raising or lowering the bar of what gets kicked up. Okay. Well, right, nothing would get kicked up unless the person appeals. Okay. So I guess you could say it raises. Okay. Right now, when staff reviews moral character, it's kind of a team thing, right? It's not just one person sitting there crunching, looking at papers, right? There's a whole bunch of people in staff involved in evaluating moral character. Is that true?
Well, it's a process. It's an escalating process. So it can be cleared at a lower level, they can be cleared at an upper level, depending upon what we find in the seriousness of issues in their background. Until it finally gets to my level where I review the more serious cases and decide whether to clear them or pass them on to the committee because of the seriousness of the backgrounds or other issues.
So is this proposing that there would still be informal conferences, but they would be conducted by staff? And would it still be like 3 people on a panel or something? Or would it just be one person conducting the informal conference?
It's probably the process we'll have to sort out.
So that also might impact staffing, right?
Yes.
You may have to hire more people.
So going back to that point, Larry, this is why I think this is different. if in fact 3 staff members are going to do an informal conference and that person appeals, do we bring those staff members in and do we cross-examine them on the informal conference? When we do an informal conference, like today, and I'm going to specifics, Paul cross-examined the examiners and said, why did you do this? What was your basis for this? So is the plan that you would bring staff in and we would cross-examine them at the hearing? Do you deal? That doesn't make sense to me.
It's de novo, isn't it?
I think you would need to give staff time to come up with a process. This is conceptual, and at this stage, I think that's appropriate. I do think it's important to ask why. So we have been subject to some criticism, and certainly I think in Elise and Melissa's report, you see some of the issues associated with our process. There is a lot of value to having volunteer members reviewing these applications, but there also are concerns about consistency over time, the consistency of the results. Certainly, I have heard directly from staff that the same case would get a different result based on who was hearing the case at an informal conference. That is not necessarily the optimal way for us to be making these kinds of decisions. And so that is the policy issue. If there's a determination really by the board that this process should change, we will obviously have to come up with the mechanics of how that would be done.
If I may, if inconsistency is an issue, I think inconsistency is often guaranteed unless you have one single person that reviews all cases, which I don't believe it's going to be the case. So unless I've been informed that the staff includes only a single member, then I don't think it's going to cure this defect. But again, I mean, when we say staff, what are we referring to exactly? Are we referring to a panel of staff members consisting of 10, 15, I don't know. Can you give me some information about who the staff people are?
We have not gone that far, but right now.
But the number of staff moral character analysts you have is 8, 9?
I'm sorry?
The number of moral character analysts that you have.
I have 8 or 9 investigators.
And what I would say about the ability to calibrate among staff, calibration is something that is very important for us to ensure throughout the organization, particularly if you think about an area like the Office of the Chief Trial Counsel, where we're bringing charges. We do, as a public protection agency, have a fiduciary responsibility to ensure that we're being consistent when we make decisions, even when those decisions are being made by different people throughout an office. So certainly with a group of 8 to 10 staff, if this was to be taken in-house, there would be policies, there would be criteria that would be established, and there's a management structure that would review the decisions that staff are making to ensure that the calibration was appropriate. So that is how you manage this kind of process when more than one person is doing it, and we are quite familiar with doing that work here throughout the state bar.
David and Larry?
I think one of the important things about maintaining consistency with moral character is Mark or any other individual who has managed this. Every individual that we have interviewed in the past may be different and perhaps a different set of facts. Just like I always tell my clients who are charged with crimes, that they'll say, well, this guy got something different. I'll say everybody's case is different with a different set of facts. But if there have been times when I've seen facts that are somewhat similar, but of course there's some other different set of facts or something that's not something that's different here. But everybody is discussing that particular case. We may come up with a certain decision, but Mark will remember a case that he'll bring us back in and say, well, maybe we should do this or maybe we should do that, because he has that historical knowledge. And if it wasn't Mark, it was somebody that was before Mark or somebody that was before that person. But that person that sits in that particular chair is always a person that's always brought us members back to reality to try to maintain that consistency. So I think that that us members, whenever we've sat as members of moral character, we've always taken our job extremely seriously, extremely serious. And we've gone out there and cross-examined these individuals to try to elicit and get that information that we believe is important to determine whether or not they should become members of our profession. And again, in the end, we make our decision. But again, if there's something that we should do, it's Mark or his predecessor that always brought us back to reality. So I think that me personally, the way we've operated this system in the past has been a very good system.
Larry?
Yeah,
Larry and then Karen.
okay, so I think what this group should not do is get hung up on the details of how this will be implemented. If it is, it's too early. And I think we should look at the mega thing about this. And it's two things, okay? The consistency thing is definitely an issue. I've participated in a bunch of moral character sessions, and I flagged that immediately as a concern. There was a lack of consistency. Now, I think you can have more consistency on a staff level because people are on staff, you give them a set of rules, and it's their job. And basically, if they're not consistent, then you have workplace issues that you deal with because they're supervised or whatever. But when you have volunteers doing it, you can't enforce consistency as rigorous, okay? For this, but on the other hand, it's like the old thing: your strengths are your weaknesses. The fact that they are volunteers brings me to the second big thing, which is people are being judged by quote, a jury of their peers, by the public, by other attorneys, by existing attorneys, etc. So it's all about justice in a lot of ways. Juries in the criminal justice system aren't perfect, and there are all kinds of controls to try to make it as close to perfect as you can get, but you can't make human nature perfect. So I think the issue for this group, so I'm not making the argument one way or the other. I'm saying this is the choice. You go with the staff, and yeah, you're gonna have more consistency, and you also might address financial issues, which are of course important, because the bar has a responsibility to its members, to the taxpayers really, because this comes out of the court's budget, and that's paid for by taxes. And then on the other hand, you have the issue of justice. What's fair to people? And is it fair for people to be judged primarily by bureaucrats? Like using that. I'm using that term to kind of. I'm using that term to dramatize my point. Okay. They're being judged by staff people, and it's not necessarily the most fair and most just way to do it. So, is there a balance? Maybe changing the level. Maybe you do have staff do moral character, the informal conferences, but you change the level, the burden of proof or whatever, the level of where it gets kicked up to us. Maybe that's how you compensate, for that. I don't know, but those are the two things you got to balance on this. And I think this issue is one of the most important ones in this whole document. This really goes to the heart of, protecting the public, but also being fair to the applicants. People have rights. Okay? You are making decisions about their futures, and so it is a very heavy burden on us to be fair.
Karen and then Angelique.
Yes, so I'll just start with this. When I look at this and have a couple different comments. First of all, I think there's a great concern about this issue of we're going to institutionalize and have the informal conferences conducted by the staff. I would have a great concern for the due process rights of the individuals. I think that having a fresh pair of eyes of people that are not necessarily volunteers, and our job is public protection. Our job isn't concerned about whether we're going to make the person above us in the food chain happy. Our job is of paramount importance is our public protection mission. We come into those informal conferences the first thing. Second thing I would say, I think there's a reason why we started out, and I read a report back in 1985, when we had 11 members of this committee, and 9 were lawyers. It is of great benefit to have people that are skilled in examining individuals ask those questions. And I think it's particularly true in the area that's been one of our biggest problems, which has been the unauthorized practice of law. It is helpful to have somebody that's actually understands what an experienced lawyer that's helicoptering in says, well, I really wasn't practicing law. Well, yes, you are. Here's the thing. And I think that is a great benefit as well. I think it's absolutely essential to have our public members participate. And there's nothing better than being able to see how someone answers a question in real time to see exactly what those responses are in terms of credibility, because moral character deals with the issue of candor. That is one of the core things that we look at, and how people respond in real time is really critical. So I agree with Larry. This is an area where the case has not been made. I'll say this, I think it's really important. The case hasn't been made to change this. It does come out of, probably of the report, the Walton Parker report, I consider to be inflammatory, lacks basis, and lacks credibility. There's statements in this report in the moral character context that are wholly inaccurate, untrue, and without basis. And so when comments are made to the extent we shouldn't be getting into the issues regarding substance abuse, mental capacity, drinking, apparently those people never sat in an informal conference. We don't evaluate that unless they come in with some criminal conviction or some issue that gives rise to them. So we don't do a test on it. Yet 28% of our lawyers in our state suffer from clinical depression. Over 21% of the lawyers in our state have significant drinking problems. And it's untold the number of lawyers in our state that have drug abuse problems. And I can tell you, because I practice in this very field, the number of lawyers who have committed ethical violations that have mental health problems, substance abuse problems, and drug abuse problems, drinking problems, that's a big problem. So to say we shouldn't be involved as lawyers in this, I think this undermines the public protection. So if I were to look at all these things, this is the area where the report by Walton and Parker is way off the mark. It's unreliable. We should absolutely discuss training issues. We should absolutely try to be as consistent as we can every day, every one of us. We should do everything we can to give a decent, like I did with discipline standards when we wrote discipline standards, a decent parameters for what sort of consequences we are going to have for certain conduct, but absolutely this should not be taken away from the community. Angela.
Dr. Bolton, you had your hand up for me.
Oh, I'm sorry, I didn't see you.
I just wanted to know what evidence you have that the proposed change you want to make would be the best thing to do. What evidence do you have?
I don't think there's evidence. We have a report from consultants. We have certainly heard from others. Recently, some of us have engaged in meetings with folks from Stanford University, for example, about our moral character process. We know that in other jurisdictions, as pointed out in the report, there are more codified and publicly available standards. Stanford folks were particularly interested in something that we raised earlier, which is how we use, do or do not use information about prior contacts with law enforcement as part of this process. So I don't have proof that transitioning to this model is going to solve or fully address all of the concerns that have been raised. But I do think that in general, you are more likely to have a consistent process when it is done by staff than when it is done by volunteers. So,
and that's based on what though?
That's based on the fact that your volunteers cycle through, that your volunteers are not doing this work full time, that they cannot be expected to have the same level of training. Certainly, if this becomes a part of the job description for a moral character analyst, it may ultimately require us to revisit the MQs for those positions and change them over time. Those are all things that we would be able to do with staff. You can't exercise that level of management over volunteers, nor should you. So those are the kind of things that I think that the board should take into account.
So I do have a couple of comments about the things that I've been hearing as a public member. One, I guess my feeling is that I like the current setup. That as a public member, as a person without any kind of legal background, you do get to have your input as to whether or not this person you're listening to is somebody that you can now trust to go out there and serve as an attorney. And so I would like that input way early on. The second thing is, it said in the document that there have never been any studies that there have been failures on the part of the Moral Character Committee in letting loose upon public somebody that eventually became dangerous. And so to me, it seems like it's all theoretical, that they're not doing their jobs properly the way that it's currently set up. So unless you can come and tell me that, look, you've done a poor job because you let X, Y, and Z in, then they're doing fine. So those are my thoughts about it. And I guess there is one more. I kind of turned off paying attention to this topic when we started discussing how this alternative perspective of using staff, that there wasn't even a solid plan as to how it might look. That takes a lot of trust on my part to simply say, yeah, go ahead, change it. Change it to whatever it might be for you. But that doesn't necessarily mean that it's good. It's just something that you think for yourself. So I guess I don't trust making changes when what you're giving me is something that hasn't even been well conceptualized.
I just wanted to comment on consistency. I think it also depends on what you consider consistency, because you can have people with the same background, and one has an attorney saying, say this, because this is what they want to hear, and they sound like they've been told by an attorney, this is what they want to hear. And then you have someone else who is genuine, and who you know they mean it with their heart. And this person, you have no problem putting them through. And this person, you think, there's no way. This is a denial. Now, there's inconsistency there, but the background is the same. So, you know, are you going to say that that there's some kind of problem there, or was that the correct decision? So what do you call inconsistency? There have been people who, on paper, I've seen them and thought, there's nothing this person can say that's going to make me even consider admitting them. And then they come in and they're contrite and they're remorseful and they've learned, they have rehabilitated. And it's clear, in my mind, absolutely let them through. And it surprises me. Now, anybody else looking at that paper is going to say, how the heck did this person go through? So I don't think you can tell by looking at somebody's application that, oh, well, this person shouldn't have gone through, this is inconsistent. But that's just my 2 cents. Dr. Bolton?
I just want to echo what you said. And by putting all this emphasis on inconsistency, you're then ignoring the purpose of an interview in which we look at individuals. Individuals may have committed the same crimes, but when they come before us, they present themselves in different ways. And part of our response is based on what they've done and how they present themselves to us.
So I'm definitely the newest member of this committee, it's no secret. One of the things that I take a lot of value on is actually having committee members involved in this process. Because when I look at each of you, I don't just see you as a volunteer, I see you as someone coming from an esteemed field or esteemed background. For me, myself, I am an appointee of the Speaker of the Assembly, but that doesn't mean I would just pick up off the street and say, hey, come on and join us. I have a background, I have a perspective, I have a family. I'm one of the only members that represents the Inland Empire, which is a very different community than some of yours. And that's not saying that mine is either, less, or I just have a different wholesome perspective. And so I think in removing removing committee members from the process kind of strips that away, in which you actually get a more humanistic perspective in the process. And so while you may get criticism about consistency and so forth, I think what Mr. Bolton stated is actually very true, whereas when they come before you as an individual, you have the ability to assess them. And so I think for me, when I think of the mission of diversity and inclusion in the justice system, that's what it is. It's a diverse people coming together and actually having that opportunity to hear these applicants. And so I think to remove that from us is very detrimental to the public and for people that wish to go into this field. Because for me, I value your opinion when I do evaluate some of these cases and hear some of you say, well, this person came before us and this is how they presented themselves. And I say that because a lot of you don't come from, particular, you guys come from very esteemed fields, very esteemed backgrounds. Some of you are appointees of the governor. And so I take that with a high regard when I make my decisions. And so I think it's just not appropriate at this time to strip that away from the committee.
Thank you. And just one last thing, I would note that the state bar rule 4.46 would have to be changed, and that also requires public comment, correct? So that would have to go before the membership to be changed. Any other comment on moral character?
All right, so the next function is testing accommodations. This is, again, two functions. This is a review of the petitions that is currently carried out by staff with support from consultants, and there is no recommended change to that process. And the next step the method in which we carry out testing accommodations is in the review of appeals, whether they're denials or partial grants. Those come to the CBE, and the recommendation is to keep that same system. Are there any questions or concerns? And I just want to point out what Larry noted earlier, that the moral character of recommendation is one that parallels the testing accommodation. But with that, does anybody have any concerns or questions about the testing accommodation function recommendation? All right, so the next item is, this is policies looking at eligibility to sit for the exam, challenges to exam policies, Chapter 6 violations. We've done some of those today. People who want to appeal also, time limits on their status for whether it's a bar exam or how long the moral character application stays valid for. So again, these are policies, and so the recommendation is for staff to make the initial determinations, which is what we do, and then for any appeals to come to the CBE. I'm sorry, it's a change. So staff would make the initial determinations, and then appeals would come to the CBE. Sorry about that.
That would require a rule change to State Bar Rule 4.70 and what follows. Is that correct?
No, I don't think so. So which for the Chapter 6 violations.
For the, it says at the bottom, inconsistent State Bar Rules 4.70 as
Yeah, it's like, see, it says one inconsistent state bar rules. It's, the one rule that we have for the Chapter 6 violations is that a subcommittee is appointed by the CBE to do the initial review, because it can then go to other members of the CBE for the appeal process. So that rule would have to be changed if it, you know, this recommendation.
So that would have to go for public comment.
Can I ask the question? I just don't quite understand this. Maybe I will guess on this. What's the reason for this change?
I'll throw out a suggestion. I think it's the same idea as the moral character and testing accommodations. All of those kinds of reviews would be done in the same way, where the initial review is done at the staff level, the appeal review goes to the CBE level.
So you've heard we didn't like either of those. So I want to find out, if you're dealing with Chapter 6, has there been some groundswell concerns with Chapter 6 decisions from our committee have been either wildly inaccurate, baseless, without merit, frivolous, or something that would warrant a change?
And that's the concern, but Lisa, you've been handling the laws in Chapter 6, right?
Yeah, I'm assuming, I wasn't in the, when this was developed, but, so does that mean that, so right now what we have is the subcommittee review them, or the subcommittee, and then after the subcommittee reviews, then if there is a denial, and then it has to go, and then it gets communicated to the applicant, and the applicant wants to have a hearing, that the hearing would have to be heard by a different subset of the committee that was not involved in the initial decision. So is this saying that staff does that so you don't have the problem of having to divvy out the hearing being done by different members of the subcommittee because the subcommittee didn't initially hear it in the first place?
Yes. So the idea behind this is these are a lot more administrative. So you've got somebody who brought his cell phone in, right? The cell phone was in their back pocket. They didn't realize they had a cell phone when they came in and they sat down in the exam. We present that to you and you make the determination of.
No, what happens with the cell phones is that it's a zero tolerance. So the cell phone is like a strict liability thing where except that it's
we still
affirmed.
bring it to the committee.
It's
So that's
affirmed.
right. And so these tend to be administrative type of issues. And so we're trying to take the administrative type of issues and put those in the hands of the staff and leave the committee to be doing the more sort of high-level policy thinking and the tracking of the trends and licensing and doing the appellate work, if you will.
So can I just say this? I have some concerns when I find out that Lisa, that's been involved in the testing and examinations, wasn't even involved in the process for this. She's the person that's the most knowledgeable, so when I ask why to make a change, I would expect somebody to say, well, we've had these huge problems, or it's tremendously time consuming, or something, not the person that knows this stuff basically says, listen, this really hasn't been an issue. I know it hasn't been an issue. I think this is again, not substantiated. So that's why I want to hear why you want to make a change and why Lisa wasn't included in this process.
So again, one of the things that I would point out is that the point of the appendix I review as a whole is to really take a global look at what should the role of volunteers and volunteer committees be in a regulatory agency. How can we best utilize the strengths of the volunteers that we have? And so in looking at that process, one of the things that we're doing is saying, what are some of the things that are more administrative that don't make as much sense to use the volunteers for, that can easily be done with staff? It's not an exercise in finger pointing where we're saying, you have done something wrong here and you've made errors and we need to take that away from you. It's really looking at what the appropriate structure is for volunteers and volunteer committees in a regulatory agency. What is the best use of your valuable time and your brain power, and what can and should reside with staff?
Well, the other problem though is if she doesn't know what the difference will be if a staff member replaces a volunteer, there's a problem there too, because she hasn't been consulted with.
I think Tom is making the point that the process that you're seeming to be undertaking is that there's proof, there needs to be proof that something's wrong.
No,
And what
I have
we're
a
just saying is from
different
a
concern.
policy perspective, it's a question of whether or not we should be asking committees across the board to be doing very administrative things.
No, I have a
That's the
concern that
question.
no one's consulted with Lisa.
I understand your
That-
concern, and I think that's probably unfortunate timing, that
There-
why that didn't occur, but I can assure you that before this would be implemented, Lisa and her team would be involved. And it is a policy question, should committees in general be performing very administrative functions? That is the policy question, and that is, the answer to that question is, or at least from my perspective, is that no, committees should not be performing administrative tasks. That is something that CBE has historically engaged in quite extensively, but I don't believe that is the appropriate role for a committee. You will see that when we get to the budget as well, personnel issues. These are administrative, not appropriate for a committee, in my opinion.
If I could ask Lisa, what kind of decisions currently does the CBE look at as far as eligibility to sit for exam and challenges to the exam policies? What comes before the CBE?
The eligibility issues, those would be an O&M function. I think that Chapter 6 traditionally was also an O&M, but it got shifted to my subcommittee examinations because in the larger context about discussing whether or not we should dissolve the subcommittees, that was one of the issues, Chapter 6 issues that might be something that would come in between exams that we would need a subcommittee to deal with. And so that was in the context of that I believe this Chapter 6 stuff came to my subcommittee, but normally it would be an O&M. So the eligibility definitely is not an examinations subcommittee. So.
Okay, and then why was it necessary to come to examinations?
The Chapter 6?
Yes.
The Chapter 6, because some of the Chapter 6 issues would be ones that would need to be dealt with in between meetings, and that's why the proposition was that at least the examination subcommittee would remain in existence and would not be dissolved in order to be able to deal with those issues.
Okay.
Can I make a comment?
Yes.
So I think, one of the things that we're trying to do here is figure out, and this has been a challenge in all these conversations with all the different sub-entities. On the one hand, we're trying to look at this globally and from a policy perspective, and the question there is the one that was just framed, which is, what is the best way for the bar to make use of your expertise? And unfortunately, that the perception is that it's, oh, you're trying to strip us of our authority, is sort of how some of the reactions in some issues are. And I think and the question then arises, well, how exactly would you do that? And I think that's also challenging, because if you're trying to make policy, the question you're trying to ask is, what's the right thing to do? You're not yet at the question of what's the right way to do it. And so, for example, if you were going to talk about women's right to vote or the Civil Rights Act, the way those things got passed was to say what's the right thing to do. All of the detail about what that means, all the implications of that for people, for employers, for this, for that, was what got worked out after the policy path had been set. So that's kind of a big dramatic example, and I use it to make the point that this is the challenge of these conversations, is figuring out what's the policy decision we're trying to wrap our minds around, and then trust the process that's going to create a collaboratively architected solution for that. And I think there's some tension there too about, can we trust you to really architect a process and involve us and make a process that makes sense? And I think we're trying to get to that what's the right thing to do question, and there it's really is guided by how do we do this most effectively, because again, the Board of Trustees is managing a process that involves 250 plus volunteers across multiple sub-entities. That's a governance challenge that's huge. And so part of this is about looking at it from a perspective that we all have to sort of reach for, I think, these conversations, which is what does it look like if that's where you are and you're really trying to manage this? Because to be honest, the way I see this personally, historically, board was not sufficiently involved and kind of left people to do good, honoring their intentions and willingness to serve. And that's okay, but it's not governance. And then it's not surprising then that these questions arise like, well, who are you and how can you be trying to change what we're doing? It seems to be working. And whether it works or not, I don't think it's actually going to perfectly answer it in most of these areas, because they mostly have not been evaluated. It's never been looked at. Do people that score higher on the bar, are they more successful, or is the test measuring their competence going forward? Do the moral character people who would get rejected, do they go, what happens to the people that are, this whole exercise is filled with those kinds of questions, but I think that can't stop us from trying to figure out what the right thing to do is, and really it's to try to make the best use of your expertise in the role, and I include public members in that context. Thank you.
Any other thoughts on the eligibility, Chapter 6, the challenges? Any other Angela's?
I think at our last meeting, we had some Chapter 6 issues that were discussed. I thought it was educational and important that it was discussed here at the CBE instead of having it done by a staffer. I think, to be honest, one of them probably would not have had the outcome that it did. And so I would prefer to have Chapter 6s still kept as a discussion point within the committee.
Thank you. Anyone else? All right, the next two items are related to budget issues and personnel issues. On the budget issues, the recommendation is for that function to be carried out by staff, which is a change to the current operation. And we see that in the form of the budget updates that happen in the O&M subcommittee. Let me stop there and find out, are there any thoughts or comments, suggestions?
So would we not get at least the budget updates on a go-forward basis?
Yes, we would not.
Because I had many things yellowed, but I assumed, I guess incorrectly, I assumed that we would still at least get the report. I mean, I understand Leah's concerns about having a bunch of people questioning decisions at a micro level, but the idea that we wouldn't receive a report on the finances of the committee for admissions, I find that to be amazing. There's not a basis to, because we're not, it takes, what's it, for all of us, I think we spent 5 minutes at most when we received the reports and maybe ask a few questions, but to do our fiduciary duty as committee members, to at least be able to ask questions, I don't know, I find that to be troubling. I mean, I'm not asking to be able to do and micromanage the decisions made about line items in a budget, but the idea that we would no longer get a financial report, I don't think that's a good idea. And I actually didn't even have that. I assumed we'd get the report. I assumed it was going back to the idea we wouldn't be in the weeds in terms of the details. So I would think that you would want to rethink that.
Other than the administrative concern, what is the factual basis for withholding the report from us?
Well, it's a matter of whether that's consistent with the current rules. I mean, right now.
Which rule is this?
If you look, we have the rules that, that the CBE has a power to be delegated by the board. We've traditionally, I think, brought that item to the CBE and not acted on it. You never look at the budget. I mean, we might talk about where we're at. I think questions arise about, not only the accuracy, but where we stand and whether we are forecasting whether we're going to remain within the budget or outside of the budget. And the idea with this review was this is not a licensing function that's carried out from one jurisdiction to the next. It's not a typical licensing function for this group. So I think the idea is to pull out both personnel and budget from the CBE. And, you know, that, what we do here is do a check on the status of the budget, but budget decisions are not made. So the change is not so much that we would not, that you wouldn't carry out any decisions. You don't make decisions right now, you review the budget, and that would just be an administrative function that would stay with the staff.
It's just to clarify, this is the only committee that I'm aware of that has historically been reviewing budgets. So there is up in the exam development or one of these categories, a recommendation that the CBE continue to be engaged in setting the exam fee. So if there was a desire to change that fee, certainly we would have to bring forward as staff the full array of financial information to justify that fee. But the approval of the annual budget for the bar is handled by the Board of Trustees every year. And as I indicated earlier, the board on a quarterly basis reviews the bar's financials across all functional areas of the bar. The board delegates to me as executive director responsibility to manage the budget. There is no role, in my view, as I see it, for a committee to also have oversight over the budget that is established by the board, and then I am responsible for monitoring. So I understand this is quite a change from what has historically been done, but CBE is not, is an outlier even with respect to the many other committees that we have at this time. This does not seem to be an appropriate function for any committee to perform. Again, a separate and distinct from the exam fee. And certainly at a time when we want to change the fee, significant financial information would have to be brought forward to justify that.
But not only does the CDP look at those things, but we also kind of serve as a valve for the public to see those things. So public members are here, committee members from the various schools, and if we're not seeing things, they're not seeing things either. So I don't think you're intentionally trying to hide things from us, but as a result of what you're doing, you're basically keeping the public unaware of certain things that I think the public needs to see. I think just Karen's trying to say these things need to be shown to the public. Even if we're only being shown them, they should be shown, they shouldn't be kept behind.
Well, the budget, the budgets that are submitted to the board are public. The budget that is submitted to the legislature annually is public. There's an extensive narrative in that budget document. There are workload and performance metrics in that document. The quarterly financial statements that are submitted to the board are public. So there are public members on the Board of Trustees. So I think there is certainly the ability for the public writ large to review and oversee the state or opine on the state bar's budget. And in addition, you have the Board of Trustees with that clear fiduciary responsibility with respect to the budget for the entire state bar.
When I was a liaison with the CBE and also a member of the Board of Trustees, I was really engaged with the CBE at that time. And one of the issues that we were looking at is why are we paying so much for bar examination? Which is why, again, we went into the study of considering a 2-day bar. And I remember one of the members at that time, somebody who was sitting with us at the time, was Pat Dixon, and several other individuals, and which is why we brought in Roger Bolus and several other psychometricians to engage again in a robust discussion as to whether or not a 2-day bar examination would be a viable option. But one of the things that we had discussed at that particular time is that the savings alone would be $1 million that I recall. And that's one of the aspects that we discussed with the Board of Trustees, that we would be able to save some money for the bar at that particular time. And that was one of the concerns that we had. Another concern that we had was the cost of putting on the bar in terms of the accommodations. We're looking at, and we still consider the accommodation cost for the cost of special accommodations. That's another concern that we've always had, as long as I've been a part of this committee, and as long as I've always been a part of the committee as a liaison. And I think that these are major concerns that we should have as a member of the CBE as well. So again, cutting us off from budget concerns, I disagree with that, because I believe that that is a concern that we as members of this committee should have. So, again, that's my piece.
Anything further?
Yeah, just if we're going to have to on occasion consider that this information is going to be a part of that consideration, and just trying to dump it on us with 5 days to review it, rather than letting us periodically have an impression about how things are going, seems like a recipe for more friction than we need.
Anything else?
The next item is personnel issues, and that's a function that would be carried out by staff as it is now, and so there are no changes. The next item is transit licensing and certification. So this is we see in the form of attending conferences related to the bar exam, such as the National Conference of Bar Examiners, the CBEs, and active participant, or just engaging in learning about the current trends in licensing in general. So this is, the part that's not new is that we do have CBE members that go to the annual NCBE conference, but this is also looking at other training opportunities or venues where the CBE members could learn about current licensing trends.
And just to add to that, as you all are aware, last year we did the studies of the bar exam, and that had been the first time in many years that those studies have been done. And the idea here is that that would not happen again. And obviously that's not the exact same problem. It's not going to happen again because we have a rule that says we have to do a study every 7 years. But the idea is that CBE would be explicitly tasked with staying abreast of trends in licensing, not just licensing for lawyers, but also licensing more broadly. And so that you would be able to bring forward recommendations to the board of things that should be considered going forward. And that obviously, those recommendations would be incorporated into the studies that we have to do now on a periodic basis. So this is looking at other jurisdictions nationally and also internationally on the legal licensing front. There are some other countries in the world that are much more innovative than we are in the United States, and we don't have a place at the bar that is really tasked with studying that deeply, and the idea is that the CBE would be that entity.
So Erica, we used to have a committee back in the 80s, long-range planning that would have encompassed this. So, I think this is like what is old is new. I don't think it's a bad idea. I think it's a good idea, but I think this is something that kind of in cycles has come back around. So.
Okay, so is there a motion? Mark, do you have a motion?
That was okay. No, it's not. That might be long as okay. On this report. No, this one, I'm saying this idea of having this new focus of being trends in licensing certification.
Oh, okay.
I've always thought that's a good idea. I've always thought, I agree with Leah.
Oh, sorry, I was in shock.
That we've been somewhat focused.
Not as shocked as I.
Thank you. There's been a tendency, now I do, because I'm passionate about the future of law and what it's going to look like for the next generation, maybe because I have a son that will soon be a lawyer. That what we don't do enough of is talk about what we can do in the future and how we can make this a better bar. And this, I think, is part of what got us a little behind the wheel. We got hit with, the what's wrong with the bar exam sort of thing. And absolutely, when I look at this, I think that, yeah, we should be jumping on this. Absolutely, 100%.
Here for the virtual bar.
Well, I think it's also, I would hope that as part of this, CBE really takes a look at medical licensing. I'm really interested in that. They incorporate it into their MCAT cultural competency. they're ahead of us, and I think we have a lot to learn. And having a committee tasked with really understanding that would be quite valuable for the bar.
And to give another much more mundane example, so in the accountant world in California, the Board of Accountancy regulates not only the individual accountants, but the firms. That's an interesting idea. That's an idea they've done in England, and some, there are criticisms of that the English version, the British version went too far in the, oh, don't worry, the market will take care of it, the firms will regulate the behavior of their members, we'll just regulate the firms. But it's an interesting and rich discussion about whether and how that makes sense or not. So I think there are a lot of issues out there. Just trying to get my mind around this. I've done a fair amount of quick reading in this, and yeah, there's a lot of innovation happening as people in all kinds of professions and services try to figure out.
Anything else? Okay, great. So the next one is maintaining relationships with legal institutions, and currently that's carried out by the CBE. We see this in relationship with the law school council and CBE, and I think that recommendations for that to remain the same. Accreditation of law schools. So this, oh, sorry. Any comment on that one? On the institutions? Accreditation of law schools. So this is carried out in two ways. One is staff it conducts these, carries out this function. Also, some of it is outsourced. We use contractors to help us with site inspections. And then they come back to the CBE. So the recommendation here is to for staff to carry this out or to outsource it. And the second part of that is if it is maintained in-house, that CBE would hear the appeals of denials of accreditation or branch satellite campuses. So again, if it's maintained in-house, it reflects that the TA petition model where staff are making the decisions in consultation with the outreach group and that, or whoever's outsourced it. I'm sorry, if it's maintained in-house, staff are making those recommendations or making those decisions, and appeals would come to the CBE.
And I had suggested or requested that it's not just one person, that I think there needs to be some kind of check involved. And I believe we had discussed this before, and there had been some concern by RAC as far as outsourcing this, because the idea was if there's a higher cost that is passed on to the law schools, that sort of defeats the purpose of having a less costly alternative to ABA schools, because then they're going to have to pass that cost on to the students. And I also note there is a Business of Professions code that would need to be changed if this were implemented. But do we have any comment from our public members who are present? Yes. If you could come forward to the microphone.
Hi, it's Greg Brandis, St. Francis School of Law. I appreciate the opportunity to reflect on the presentations that were made respecting the accreditation system. The State Bar in the state of California has, for many years, maintained a policy of providing a less costly, less overburdened alternative. And unfortunately, the notion of entirely outsourcing accreditation is completely non-functional. There is no competent entity apart from the State Bar with experience to regulate these types of schools. There were presentations about this. Regrettably, they were not reflected quite as completely or accurately in the reporting as we probably would have appreciated them. to have been done. Cost considerations are, of course, one of the issues, but there really isn't a competent entity with experience. I will reflect this very easily for you. I spent some time, of course, in the registered law school world, and at a time before that obligation of regulation belonged to the Committee of Bar Examiners. You probably don't realize, for many of you, but previously it was the Bureau of Private Post-Secondary and Vocational Education that was the sole regulator of registered, what are now known as registered, but were once known as unaccredited law schools prior to January 1 of 2008. And the Bureau maintains a great set of standards, but they're all business standards. There's no content, there's no expertise whatever in relation to what one should do in a law school. And that's the problem with trying to go outside the existing structure. There really isn't a competent entity with that expertise. So it's been discussed a few times to talk about WASC. That's a regional accreditor. It accredits big universities, and it does so, again, at a very high level. Its interest is strictly things like, do you have a good strategic plan? Do you have a means of measuring student outcomes? Things that are not specific to law. Obviously, the only other accreditor with any legal expertise is the ABA, and that system is the one that has brought about legal education burdening students who leave school with $270,000, $320,000 of debt because of the immense cost of those schools, or some of them anyway. So this alternative and this policy is very well served by what the committee has done. And I guess I could say, as probably the Committee of Bar Examiners' only groupie, that I think you've done a great job of the work that you've done over the years in respect to the schools. We don't always agree with you, obviously, but the fact that we have a set of rules that the schools can understand, can apply, and can maintain a high-quality education at an affordable cost, whatever other factors might be at play there, certainly that demonstrates the success of the system over many years. And I probably wouldn't spend all the time I do with you if I didn't believe in what you're doing. So I have to say, I wanted to say at the outset, it's very difficult work that you're doing today. Very hard process to go through and make these decisions. And I have confidence that you'll all do the right thing to serve the people of the state. We've heard a lot of great things about that from folks here. As you continue to embark on this very difficult stuff, just know that there are those of us out there who really believe in you, all of you, both sides of this coin, to get to the right spot. So, thank you.
I had a question for Greg, though. Greg, I don't know if you had a chance to read this part of this Exhibit I, but there is in the working draft of the June 1st, 2018, the report, there's a couple statements that I do want to ask you about.
Okay.
First statement, this is all the promotion that we see in this report for taking accreditation away from the committee. One is to bring the rigor of nationally recognized educational standards and practices to bear on the accreditation of all non-ABA approved law schools. It sounds like what you're saying is, if I understand that, there's no such entity that's around that exists to do that, true?
With expertise respecting law schools, apart from the ABA, there is no such entity.
And in fact, the Committee of Bar Examiners, with the staff that's been provided by the State Bar, has over the course of the years since these Cal schools have been legislatively authorized, has developed that expertise for oversight and guidance.
Yeah, I would say that the State Bar of California, through the Committee of Bar Examiners and its staff, because I would say you've got to give a lot of credit to the folks there, have developed the most expertise of any organization in the country with respect to law schools, and particularly with respect to delivering quality legal education at an affordable and accessible cost, which is the statutory charge.
Right. The second statement is claimed, if we outsource accreditation, that it will take advantage of the deeper skills and experience in accreditation by an organization such as WASC, a highly recognized leader in the field. Now, we already had a presentation on the WASC issue. Has there been any new developments that would make a WASC accreditation where every California school would be required to be subject to the WASC standards feasible?
Well, WASC has little direct experience with law schools. Obviously, they accredit educational institutions like Stanford that have law schools, but in general, in those settings, they don't conduct a full review of the law school. They only rely upon the other accreditor with respect to the law school. So in general, WASC doesn't have a lot of background. I've been through WASC accreditation of a law school, a state-accredited law school, which I was dean for a period of time. And their review was largely respecting a sort of higher level, strategic plan, that kind of thing. Not so much in the details of how the curriculum should be structured or what the policy should be and that sort of stuff, as the present rules here reflect. So it's my opinion there just isn't a very competent function there in those places to regulate at the level that needs to be regulated these schools.
And the third reason for this proposed move as cited in this report is to eliminate a set of activities which distract from organizational management and resources of the CBE board and staff. Now, you've had the opportunity to work closely with the CBE and the staff. Do you ever feel like you've been second fiddle or not gotten sufficient attention?
Well, no, I don't think so. I think there's quite a commitment, and I'm not in a position to say how it distracts internally within the bar or distracting to the board, that sort of stuff. I will say that the public processes that are available and used have made the whole system much better. I think that the effort, the way we've had some battles over particular issues lately, at the end of the day, that does make for a much better quality school, I think. The accountability that comes for the school from having to go through those, but also the access to the regulator that comes by the way things are being conducted here, the opportunity for input and collaboration on how to make better rules. And I would say, one prominent example, the accredited law schools recently proposed for themselves the obligation that they offer 15 units of practical skills training, that all of them be required to do that to better ensure that the availability of that kind of training to their students to prepare them for the practice of law. Well, that wasn't a regulation that was proposed anywhere within it came from the schools themselves, but there was a mechanism for it to then be considered, and ultimately it was adopted. So I think the collaboration has resulted in a lot of really important improvements to the way we do things. So, I appreciate everything that everyone is doing, and I appreciate what a struggle this is to get to the right spot to do it. This is an area where the State Bar should be justifiably proud of what it's doing, and should continue to be justifiably proud of what it's doing.
Thank you.
So, thank you.
Thank you.
I just had one quick comment, just if I understand it right, community members will be involved in the school inspection side of that process. I think that would be a lot of value and loss, because for many people like myself who don't have a legal background, the opportunity to interact and hear from the students and the faculty and all the different types of schools out there, and then bring that and share that with other community members, I think that would be a huge loss.
Yes.
I'm not saying that I'm in favor of this, but I think any staff decision should be appealable if that's the way it's working, rather than just these two categories.
So, wasn't there also a recommendation to study this? Wasn't that sort of the main?
It was for an audit. That was an audit.
So I think maybe, Larry, what you're referring to is the Walton Parker report did talk about studying it. What you've got in front of you here is a staff recommendation. And so, yeah, but the Walton Parker report talked about it potentially engaging in sort of more of a study of things.
So we're going to
recommendations.
We're going to look at the audit of the accreditation the implementation of the accreditation function every 3 years. And I think that audit would occur regardless of who was performing the
Okay, so
function.
that's a separate issue.
I think it's separate.
And that would be table B, which we're gonna look at.
Okay, so in other words, because this says staff and/or outsource, so what's the recommendation? Staff or outsource?
That's what we're discussing, and
Is that,
We don't have a recommendation yet on that, in part because we need to approach, we have approached the ABA, but we need to approach WASC to determine what it would look like for them to take this on in terms of developing a specialized accreditation process for our schools. We don't know that they will do that. So I don't think we're ready to have a concrete recommendation either way.
so in other words, for now, it's staying in-house, but we're going to study whether or not it makes sense.
I think there's WASC and also DIAC, the entity that accredits distance learning providers. So there's 2 entities remaining for us to contact. And as I said, all we've done to date, to my knowledge, is we've reached out to the ABA. The ABA's position is they don't recognize non-ABA accredited schools. So even though I think they could use the business, it's not something that they're willing to do. Yeah.
can I just, for the heck of it, get a show of hands of anybody who is for outsourcing accreditation to a third party outside of the state bar?
Well, I would recommend that we study. I think it's a very important issue. It's obviously important to the schools. It's obviously expensive. It's a key function of what we do, and I just don't think we have enough information. That's all. And I would, at the risk of coming up with something that's going to cost money, it's one thing to reach out to WASC and this other group, but they're interested parties, they're potential vendors, so they're going to have a point of view. And I think if you do decide you want to think about outsourcing, I think you bring in a consultant to study this, pay them whatever they charge, and you let them flesh out all the issues.
Didn't Greg already? I thought Greg already looked into this, or did you? I don't know. Well,
I don't by any means intend to say more than the DIAC body was an accreditor at one of the schools that I was part of. And unfortunately, they will not accredit any program that does not have at least 50% of its program being delivered by distance education, because their scope of authority from the Department of Education is limited in law programs to those, or in all programs to those kinds of programs. So they don't have authority to grant accreditation to, for example, the typical fixed facility programs here. So that's the one additional piece of information. That's why I said I didn't think there was a competent authority, because they don't have the scope to cover all the different kinds of schools.
and I believe in a prior presentation we were told the cost, and the cost was a lot. It would have been.
That's the cost for WASC to do a full-blown WASC accreditation, or the ABA for that matter, for a process for these schools. What I'm suggesting is that the next step is that we need to contact now WASC and DIAC and say, would you be willing to develop a different model or program with a different cost structure for California accredited law schools? That we have not, to my knowledge, yet asked them. So that, I don't think we can rule it out because of the cost of a full WASC accreditation right now.
So then number 1 needs to be clarified, because it's not, it still makes it look like we're considering outsourcing the whole thing.
Well, I think from a staff perspective, we are. I think what the point I'm hearing is that CDE may not think that that's viable, but
And what I'm saying is, I think it's important enough, and we don't know enough, that we should have an honest study of the issue, and a biased study, okay, which, you know, frankly, staff internally can't be totally unbiased, the schools can't be totally unbiased, the CBE can't be totally unbiased. We need an honest broker to come in, look at it all, and come up with a recommendation and say, yeah, it's a good idea, here's why, or no, it's a stinky idea, here's why. And then we can make it, but right now, I don't think we know enough to make a good decision.
I don't know if I'm like misinterpreting this function. I guess from everything I've been given to read, and there's a statement that's written on page 28 that this function of accreditation is a function that had been given to the CBE by the trustees. And my interpretation is they, meaning the trustees, no longer see it as fulfilling the more specific definition of what our role is in the CBE. And on page 28 of the Parker thing, there's a very specific statement that says burden is on the state bar to demonstrate why it should not separate it out. And so, is it my misinterpretation that really this function is something that can just be taken away? No discussion with us?
Well, and again, the business and professions code would need to be changed in order to.
I think this is also an area that, to understand, the Medical Board of California does not accredit medical schools. So it's a reasonable question to ask, why does the bar accredit law schools? It's a reasonable question.
California is a leader in the country. It's because we provide less expensive education.
No, I understand that California is very different than other states and has a variety, as it's just been described, of ways of doing it. That's clear, but I'm just saying, it's, from a point of view, if you step way back and say, what is a regulatory body doing? What should it be doing? This is one of those things where you say, wow, that's a big professional thing that whole organizations do on a specific skill set. So are we, or to ask the question a different way, in terms of the audit or review, is it being done at the highest standards of professionalism? And I say this with total respect for everything that you do, so please don't misunderstand, but that's a reasonable question to ask about all these different things that different entities do. People are doing adult education. Do they know how to do adult education? Or do they know how to do PowerPoint? Those aren't the same thing. And again, the bar wants to be functioning at the highest professional level, so that
Wouldn't
there are.
the state bar know the best about what lawyers do and how to educate lawyers? Why would it make more sense to outsource that?
Not all professions are as self-regulating as bars have historically been, and the question of whether that's the right path or what form of that path is the right path is the question I think that the Governance and Public Interest Task Force posed.
Who accredits medical schools?
An entity called the AAMC, which the M and C stand for medical colleges, American Association of Medical Colleges.
It's a national organization.
However, the medical board does approve medical schools. I know that for a fact because I was chair of the committee that chopped the medical schools and granted approval, and I disapproved.
Comment. So the way I read this was that we would consult with an outside agency, and then the board would oversee that proposal or assessment, and then we would review and approve it. That's not how it should be interpreted? No? Okay.
There's a recommendation in the table for this, for review to happen as part of this, in the second part of this table, but let's see,
So it would remove the entire authority of the CBE to accredit these schools. Is that what this is saying?
Well, there's two different options. One is that the staff or this outsourced company would make the decision. The second option that's on the table is that if the staff or an outsource made recommendation that it should be accredited, it would then come back to the CBE to agree or disagree with that decision.
I'm sorry, I didn't hear that.
Or serve as an appeal board, like
Oh,
most of
okay.
the other recommendations do.
Okay, so I echo Larry's that I think it's something maybe we could look at, but at this time I don't feel comfortable because of the lack of details and information, as well as no factual basis as to why we're moving here. I think a lot of the things that are coming up, typically when you produce or manufacture policy at the local or statewide level, there's usually something wrong and then you fix it. I remember in the city of, or the county of Riverside County, we had a private school that was operating that wasn't regulated for 13, 14 years, and they found out they were abusing children in this school at this home. And so the legislator came forward and changed that and provide more accountability measures. So I think with a lot of the things being proposed, I mean, it's just hard to understand the basis of it if it's like, how do you correct these issues that haven't been an issue in the past? However, I do see cost measures and potential to save money if we do look at outsourcing and maybe staff still having oversight and the CBE still having a part in that as well. But I just don't see how we could remove that function entirely from the CBE altogether.
And that's one of the reasons, one of the alternatives that was discussed in the Parker Walton report was if CBE were to maintain this role that they currently have with accreditation, that there would be an audit process because we don't know what we're doing right and we don't know what we're doing wrong. And so we would be auditing to see, are we following the highest professional standards? Are we looking at things that we should be looking at and having that audit done of whether our processes for accreditation and major change requests, whether those are appropriate. Right? We know we know the guidelines that we're following, but what we don't have is an assessment of, are we doing everything that we should be doing, that an accrediting entity should be doing in making the decisions that we make.
And this, my response is, of course, I think our goal should always be, how do we do better, how do we perform better? But I guess just hearing some of the commentary from the public is that they don't feel confident there's any regulating authority that could provide that perspective as the state bar does. And so definitely audit, I mean, that should be a part of the business practice as usual. But I think it's just very difficult for us to give away this entire function from the CBE for the benefit of what I have no clue. And that's me coming in with fresh eyes and reading this, as a newbie. So, thank you.
Move to adjourn and resume tomorrow morning at 0900.
Second. It's scheduled time.
We have the committee meeting also.
Yeah, subcommittee on examinations meets at 9, committee meeting is at 9:45. Open is at 9.
Subcommittee on examinations at 0900 tomorrow morning. Committee at 09:45.
We're all trouble. So we have a second. All in favor? Aye. Anyone opposed?
So what's it?
The subcommittee on exams. 6 o'clock in the lobby for
9:45.
Meeting you at the restaurant.